The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable, the Supreme Court of the Philippines shall give their attention, for the Court is now in session.
The Clerk of Court will please call the matter at hand.
Called for continuation of oral arguments are the case in GR number 2048-19, James Imbong and Lovely Ann Imbong et al. Versus Executive Secretary Paquito N. Ochoa et al. And the other consolidated cases in RH law. Appearing as counsels for petitioners James Imbong et al. And John Walter Huwat et al. Are the following: Attorney James M. Imbong and Attorney Joe Aurea Imbong. For petitioners Alliance for the Family Foundation of the Philippines Incorporated et al., Attorney Maria Concepcion Noche. For petitioners Philippine Alliance of Ex-Seminarians Incorporated, Attorney Lino E.A. Dumas. For petitioners spouses Francisco S. Tatad and Maria Fanny C. Tatad et al., Honorable Francisco S. Tatad. For petitioners Couples for Christ Foundation Incorporated, Attorney Luis Francis Rodrigo. For Counsel for Public Respondents, Honorable Edsel Silagman. For the Office of the Solicitor General, Solicitor General Francis H.R. De Lesa. Assistant Solicitor General Hermes L. Ocampo. Senior State Solicitor Florian T. Hilbay. State Solicitor Maria Sofia Obieta Palad. Associate Solicitor Christian Louis Gonzalez. Associate Solicitor Emerson S. Bañez. Associate Solicitor Maximo Paulino T. Season III. Associate Solicitor Leia Teresa Labadan. Associate Solicitor Elvira Josel Castro. And for intervenors Cabral et al. And Senator Pia Juliana S. Cayetano, Attorney Elizabeth Aguiling Pangalanan. For intervenors, the Filipino Catholic Voices for Reproductive Health, Interfaith Partnership for the Promotion of Responsible Parenthood Incorporated, Emelisa Baya Mones, Zaria Mapandi, Attorney Clara Rita A. Padilla. Senior State Solicitor Florian T. Hilbay has 15 minutes to argue on the freedom of speech and religion, academic freedom, and local government.
Please proceed, Solicitor Hilbay.
Your Honor, Madam Chief Justice, Honorable Associate Justices, good afternoon and may it please the Court. My presentation focuses on a set of challenges on the constitutionality of various provisions of the RH law, grounded on claims that the law violates freedom of religion and freedom of speech. Number one, it is argued that the RH law violates the Constitution insofar as it penalizes the refusal of health service providers to perform RH services or provide information on RH. What Section 23, Paragraph A, Number 1 of the law penalizes is the act of intentionally providing incorrect information regarding RH programs and services. The government submits that no one, not even those who object to the law on religious grounds, has the constitutional right to intentionally provide incorrect information. To grant immunity for such act is to give license to the religious objector to potentially inflict harm on a patient who relies on incorrect information intentionally given. One's religion cannot be used as a justification for inflicting injury on a fellow citizen and transforming innocent patients into victims. The law is reasonable in another regard, in the sense that it recognizes the right of those who oppose on religious grounds to conscientiously object. This opt-out provision is a significant state concession to an objecting citizen's religious belief. It allows her to keep silent in the face of an inquiry by a patient regarding RH services and information. Section 23, paragraph A, number 1, is a penal provision of a health legislation regulating the responsibility of healthcare professionals towards their patients. It has no speech component and therefore cannot be subjected to a facial challenge. Number 2, Section 23, paragraph A, number 2 of the RH law penalizes the refusal of a healthcare service provider to perform legal and medically safe RH procedures on the ground that spousal consent was not obtained. It also provides that in case of disagreement, the decision of the one undergoing the procedure shall prevail. Petitioner Couples for Christ Foundation argues that the law violates freedom of religion, quote, as it confers upon the wife sole authority to decide on matters relating to her reproductive health in disregard of their Catholic faith, which gives the husband authority to decide in cases of marital deadlock pursuant to God's divine order for the family as set out in the Holy Bible, unquote. What the law recognizes is the constitutional right to liberty and privacy of either the husband or the wife to undergo an RH procedure. It is gender neutral and therefore does not discriminate against the husband or the wife. On the other hand, petitioner's argument that it is the husband who has the sole authority to decide on RH procedures not only violates the liberty and privacy rights of women, it also violates the Equal Protection Clause and the specific constitutional policy recognizing the fundamental equality before the law of women and men. What Petitioner Couples for Christ Foundation wants is for men not only to have the right to undergo RH procedures such as vasectomy, even without the knowledge of their wives, but also the right to override the decision of their wives to have ligation. This is not only unfair, it is also unconstitutional. Such belief cannot be translated into public policy without violating the Non-Establishment Clause. Section 23, paragraph A, number 2, is a penal provision imposing a responsibility on healthcare professionals not to discriminate against women. It has no speech component and therefore cannot be subjected to a facial challenge. Number 3, petitioners question the constitutionality of the RH law insofar as it requires the conscientious objector to immediately refer the person seeking such care and services to another healthcare service provider within the same facility or one which is conveniently accessible. It is argued that the duty to refer is unconstitutional because it compels a conscientious objector to become a party to an act forbidden by his faith. The government rejects the argument that the duty to refer infringes an objector's free speech rights. The refusal to perform one's professional duty cannot be considered protected speech because the refusal to refer cannot be equated simply with the communication of an idea. It is an act that creates a victim in the form of a patient who is denied access to RH information or service. Implicit in the duty to refer is a carefully balanced compromise between, on one hand, the interests of the religious objector who is allowed to keep her silence but is required to refer, and on the other, the citizen who needs access to information and who has the right to expect that the healthcare professional in front of her will act professionally. The Honorable Court should view the duty to refer in the context of the fact that a hospital or any other healthcare environment is not considered a public forum for purposes of applying free speech or free exercise doctrines. A person who visits a hospital is looking for a person of science, not a theologian. She therefore expects expert medical advice, not religious instruction or political debate. At the same time, a healthcare provider working at a hospital or a clinic presents herself to patients not as a religious healer, but as a skilled technician trained in the various disciplines of medicine. The duty to refer is also not a civic duty. It is not a political duty imposed on a citizen such as the requirement to salute a flag or fight a war. It is a professional duty imposed on a medical professional acting as such. The RH law, therefore, simply manages the reasonable expectations of patients as well as the public expectations about the duties of healthcare professionals. If, as in People versus Judge Veneracion, an officer of the court can be required to impose the proper penalty, including death, despite his religious objections, with more reason a healthcare service provider can be required to perform the lesser duty of referring a patient he himself does not want to serve. Whatever burden is placed on the free exercise rights of the conscientious objector is minimal, because the duty to refer is limited, number one, in duration. The objector has no duty to refer when she is not working as a health worker. Number two, in location. The law regulates only those places devoted to healthcare. And number three, in impact. The law does not prevent the objector from speaking against the RH law in all other forums. There is also a constitutional challenge to Section 15 of the law, requiring marriage license applicants to receive information on responsible parenthood, family planning, breastfeeding, and infant nutrition. In the first place, no one knows the form in which this information and instructions will eventually be disseminated, whether in the form of a seminar or a lecture or a paper or a CD handout. This Honorable Court, therefore, cannot rule on the constitutionality of Section 15 by anticipating the form in which this information drive is going to be implemented. In the second place, there is a clear rational relationship between marriage and the requirement to receive information on various aspects of marriage, an important component of which is the need for a heightened sensitivity about the responsibilities attached to parenthood. In much the same way that the government can theoretically require prospective spouses to receive information on financial management, it can require the same set of spouses to learn more about the burdens of parenthood. In the third place, those who object to RH information can totally reject information they do not agree with. They therefore retain the freedom to decide on matters of family life without the intervention of the state. Number 5, petitioners question the constitutionality of Section 14 of the law, providing for age and development appropriate RH education to be taught to adolescents by adequately trained teachers in subjects such as values formation, knowledge and skills in self-protection against discrimination, sexual abuse and violence against women and children, gender-based violence, teen pregnancy, responsible parenthood, among others. What is important to highlight here, Your Honors, is the crucial fact that the curriculum on age and development appropriate RH education still has to be formulated by the Department of Education. And because the law has not yet been implemented, the curriculum, which may be the basis for a constitutional challenge, has not yet been crafted. This Honorable Court has no jurisdiction to rule on the constitutionality of a provision of the law that exists only at the level of policy and whose actual content has not yet been written. Petitioners also argue that this policy on age and development appropriate RH education already violates the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character. Note that the operative word in the Constitution is the word primary, which indicates that this parental right is not exclusive. This is understandable because parents are stewards, not owners of their children. Also, attached to this right is another operative word, duty, and this powerful concept is the traditional constitutional justification for the state as parens patriae to participate in the affairs of its citizens, especially the youth. The primary right and duty of parents towards their children can reasonably coexist with the state's interest in building a nation of citizens who are simultaneously civic-minded, morally responsible, and properly informed. Number 6, some petitioners also challenge Section 17 of the law, which encourages private and non-government RH care service entities to provide annually at least 48 hours of pro bono RH care service to indigent women. They argue that in the guise of encouraging RH services, the law is compulsory given that the 48-hour annual pro bono services shall be included as a prerequisite in the accreditation under the PhilHealth. The law is not as insidious as petitioners present it. For one, the government can in fact condition the grant of a privilege, accreditation under the PhilHealth, with the rendition of some public service such as the performance of free RH service. For another, and more important, the range of RH care services enumerated in the law is broad enough to cover pro bono services by a professional who also happens to be a conscientious objector. Under the law, RH care covers family planning and information, maternal, infant, child health and nutrition, including breastfeeding, prevention, treatment, management of HIV, AIDS, and sexually transmitted infections, elimination of violence against women and children, treatment of breast and reproductive tract cancers. Surely some of these services must be acceptable to even the most ardent of objectors. The broad definition of RH care means that the medical professionals can pick and choose those RH services that are not incompatible with their beliefs. Your Honors, allow me to end with some remarks about the procedural and substantive posture of this litigation. First, the Honorable Court does not have jurisdiction over the question whether hormonal contraceptives and IUDs violate the right to life of the unborn. This is because the RH law is not the law that makes it possible for Filipinos to obtain access to hormonal contraceptives and IUDs. That law is RA 4729, a 1966 statute that predates our present Constitution and whose constitutionality is not in question here. Those who drafted the 1987 Constitution did not intend to nullify RA 4729, and petitioners themselves are not questioning the constitutionality of that law. Second, the narrow constitutional question before us is whether the government can subsidize access to devices that are already available in the market and can be bought in drugstores all over the country. The answer is clear. It is impossible to nullify a government social welfare program that, among others, only seeks to provide willing beneficiaries access to devices that are already accessible to those who can afford. Third, an on-its-face challenge against the RH law is a conceptual impossibility because, number one, the law textually corresponds to the guarantees of the Constitution. Number two, it is not related to speech in a public forum. The RH law is unrelated to the suppression of speech because it does not regulate the political and religious conversations among citizens. What it regulates is the relationship between medical practitioners and their patients. In conclusion, the government submits that the RH law is a carefully balanced statute that takes into consideration many constitutional concerns, including the free speech and free exercise rights of the petitioners. What petitioners generally insist, however, is for the Honorable Court to view this law from a single constitutional lens, the perspective of the religious objector. We submit that this cannot be done in this case without doing violence to the values and intersecting constitutional policies that are implicated in the social question of what to do with the reproductive health of Filipinos. Thank you.
Justice Mendoza.
I defer to Justice Sata.
I call your attention to the provisions of the RH law concerning reproductive health education for adolescents. Adolescents are kids from 10 to 19 years old, correct?
Yes, Your Honor.
Under Section 14, the state shall provide age and development appropriate reproductive health education for adolescents, correct?
Yes, Your Honor.
In fact, the law authorizes the Department of Education to prepare a reproductive health curriculum for public schools. That's right?
Yes, Your Honor.
That private schools may adopt.
Yes, Your Honor.
These lessons in reproductive health would be integrated into regular subjects like social science, correct?
The law doesn't say that, Your Honor.
Well, it says to be integrated in the regular subjects.
It doesn't say that in the statute, Your Honor. I'm sorry.
So in subjects that are part of the regular curriculum, the secular subjects.
What the law states, Your Honor, is this. The Department of Education shall formulate a curriculum which shall be used by public schools and may be adopted by private schools. How it will actually be operationalized will have to depend on the Department of Education. But because this is a facial challenge to the statute, we're bound by the statute only and not by what the Department of Education will do later on once the law is operative.
It says here, and integrated in relevant subjects. It will be into the teaching of reproductive health education will be integrated into relevant subjects.
Let me continue the statute, Your Honor. Relevant subjects such as, but not limited to, values formation, knowledge and skills in self-protection against discrimination, sexual abuse, and violence against women
That's
and
what
children.
constitutes the reproductive health education that will embrace those things that you're enumerating now.
Yes, sir.
But these things will be incorporated in, for example, social science. It will be incorporated in health or Filipino or such secular subjects. You don't know?
I don't know, Your Honor. But
okay,
what
well-
I know is that it will be formulated as part of the curriculum.
That's my reading of it. That it will be, and I've read a lot of modules they gave out, and they are integrated into regular subjects. So,
Well,
anyway.
we cannot say they have been integrated, Your Honor, because the statute has not yet been implemented. In fact,
well, that's what the statute wants. And I'm not saying it's now integrated. I'm saying that it will be integrated
it will be,
according
yes,
to
sir.
this law. Okay.
Yes, sir.
Now, and therefore it is implicit that attendance in reproductive health is a condition for graduation. It is a subject in public schools, and it is a condition for them to pass through their schooling, correct?
I would suppose so, Your Honor.
Now, based on Section 14, paragraph Q of the RH law,
14 paragraph.
reproductive health education covers values formation, self-protection against discrimination, sexual abuse, and violence against women and children, women's rights and children's rights, responsible teenage behavior, gender development, and responsible parenthood. But none of these are, of course, objectionable, as far as I can see. And from the,
That's what we're saying,
that's
Your
it.
Honor.
And they're actually being taught in the public schools from my reading of their curriculum. Do you agree with that?
I'm not sure if they are already being taught, Your Honor.
Well,
not
the subjects that are mentioned are
My
part of
focus,
other
Your
laws,
Honor,
actually.
is on the statute and challenges
So, anyway,
to its
my question is-
constitutionality.
Actually, what is new in Section 14 is that it also seeks to address the problem of teen pregnancy. Actually, this used to be the sole concern, when during my time, the sole concern of the affected teenagers and their families. But for some reason, the state would now want to have a hand in the problem, correct?
I don't know what is new in the statute. All I know, Your Honor, is that
No,
there
the
is
statute provides
enumeration.
for. Well, I think that's one of the presentations of Senator Pia, that this is one of the problems, teenage pregnancy.
Yes, Your Honor.
That this
We
law is
are
trying to
limited
solve. You
by our
disagree with
analysis.
You disagree with that statement?
What I'm saying, Your Honor, is that we are limited by our analysis.
No, the law mentions teenage pregnancy.
Yes, sir. It will be included.
So one of those concerns. So now, the solution, well, apparently, it cannot be helped that a number of young girls engage in sexual relations with their age groups without taking precaution, and so they become pregnant. Correct?
Your Honor, is that a constitutional challenge?
No, don't ask me. I'm asking you. Don't ask me.
My answer,
I
Your
ask
Honor,
if you
is
agree
that
with me or not.
my answer, Your Honor, is that concern is irrelevant to the facial challenge of the petitioners here.
No, that is one of your arguments. We will consider that, but assuming it is
Yes,
not,
of course.
I'm assuming that it is relevant. So don't assume that it is relevant, because you
I'm not, Your
precisely, you offered arguments to defeat the spatial challenge, so we can discuss it on that way. Do you agree?
Yes, Your Honor, and I'm just following the line of our
don't
argument.
Don't tell me these things. So, because you yourself concede for argument's sake that there's a lot of arguments. So I'm making those arguments. Now, So the solution that the RH law offers is to teach adolescents how to avoid getting pregnant when having sexual relations. That's one of the purpose of this law. You agree?
It is one of the range of solutions,
Yes. Now,
menu of solutions
do you
that are
know
available.
at what age boys can cause pregnancy and what age girls can become pregnant?
Puberty, Your Honor.
Well, that will be around the ages of 11 or 12, the beginning of puberty. So that is about grade 5 or grade 6, from what I see.
I can provide you, Your Honor, with a scientific explanation in our memo.
No, not
I
yet.
am
I'm
not
asking
a
you.
doctor, I'm not a specialist
No,
on
just
that question.
so that would be the age and grade appropriate, because I understand this education is age appropriate. No? That would be the age appropriate for learning knowledge and skills in safe sexual relations. That's right.
I suppose that would be one of the potential subjects in the statute.
Now, would you know the latest figure in the number of teen pregnancies in 1 year?
No, Your Honor.
Well, my figure shows that there were 196,000 teen pregnancies in 1 year in 2009.
Your Honor, we will try to verify that and submit an answer
anyway,
in
I've
our
seen
memorandum.
it. So, 196. Show it in your memorandum, but meantime, I'll assume it because I look at it. 196,000 teen pregnancies in 1 year. You can correct me later on.
Okay.
Now, based on these statistics I have from the NSO, there were 9,699,000 adolescent girls in the country in the following year, 2010. This means that roughly 9,503,000 adolescent girls in 2010 held out and did not get pregnant, as against the 196,000 girls who did. So what is the sense in teaching both male and female adolescents, which in the statistics number about 19,845,000 in all, knowledge and skills in safe sexual relations because of the erroneous behavior of those 196,000 adolescent girls? Because the downsides of teaching safe sexual relation to adolescents are based on what's happening in the other countries. Sexual perversion and promiscuity and weakening of the institutions of marriage and family. In the U.S., people don't get married. In Singapore and other places. And family that plague the countries which have promoted and practiced safe sex. Would the government risk such enormous downsides for the sake of the few who got pregnant?
Your Honor, that is a question within the realm of discretion of the legislature. I'm sure that has already been considered by the members of Congress.
Reasonableness and arbitrariness is within the scope of constitutionality.
So what is the constitutional challenge, Your Honor?
Well, reasonableness and arbitrariness and oppressiveness.
Of what, Your Honor?
Now, should not the government instead help these pregnant teenagers cope by providing them and their children with shelter and counseling rather than put to sexual orientation 19,800,000 of our adolescents?
Number one, Your Honor, those responses are not exclusive. Number two, again, those are policy concerns of the legislature, not constitutional questions.
All right, that's your best. Now, would you think that all parents would agree to have their children taught knowledge and skills in safe sexual relations from the age of 11 or 12? Do you think parents will agree to that? All parents?
I don't know, Your Honor. I'm not a parent.
Well, there will be parents who will not agree, precisely why we have some who are opposing this. Now, the propriety of consented sexual relations between two unmarried persons from age 11 or 12 remains an issue that involve parents. Do you agree?
Yes, of course.
Because children at those ages remain under parental authority, correct?
Yes, Your Honor.
To some parents, such kind of sexual relations can be immoral. Do you agree?
I suppose, Your Honor.
Who has the primary right in the rearing of the youth for the development of their moral character?
The Constitution, Your Honor, points to the parents.
To the parents precisely. The state's role is merely secondary. Huh? Primary means to say it's the parents' right. Now, I have some excerpts from modules in sex education prepared for public schools many years back entitled Kaalamat Impormasyon sa Katawat Kalusugan Nating Youth, or Kikay Kit. They call it Kikay Kit. These were patterned after American models. One says, the sexual urge is a natural feeling of the body that should be fulfilled. I repeat that. The sexual urge is a natural feeling of the body that should be fulfilled. And it continues, it is the body's normal response to gratify or to express physical desire. Well, this is like saying to those 12-year-old kids that you will teach that you like sex, you have the right to do it, but use contraceptives. This teaches self-indulgence. Would you agree?
Your Honor, those materials are irrelevant for purposes of this litigation. If I may, I'd like to read to you the statute.
No.
Provided that flexibility
I'm
in
not
the
asking you whether it's
formulation.
relevant or irrelevant. That is, I'm asking you if this constitutes self-indulgence. Do you not
Your Honor, are you asking me to agree with your conclusion or to disagree
answer
with
the question first
material
before.
that you have read?
You answered the questions first because I'm the one asking you this question.
Yes, of course. I'm sorry, Your Honor. Again, let me manifest, I don't see the
So you-
materiality of those materials with respect to the constitutionality of the statute.
All right. So
the
I ask
Department of
you-
Education, Your Honor, may very well reject all previous materials and start all over again. In fact, I think the DepEd has begun just that with the participation of faith-based organizations.
Well, that's your best point. Now, we ask you, does the RH law require public schools to provide parents with advanced copies of the lessons they will teach their children from age 12 concerning, or age 10 concerning sex?
The
Does law
statute,
provide?
Your Honor, does not say
Does
that,
not. Now,
although...
does the RH law require public schools to get the consent of parents before indoctrinating their children with values that acknowledge a natural right to indulge in sexual relations?
I'm not sure about the word indoctrination,
Well,
Your Honor. That's a rather strong
that
term.
Well, I'm asking you if the law provides for...
What the law provides for,
Securing
Your
consent
Honor,
from
is
parents.
that there's flexibility in the formulation of the appropriate course content, and school officials and other interest
Now, yes, ma'am, are the parents'
shall be
consent
allowed
required?
only after consultation with parents, teachers, community
the consent
associations.
of the parents of the children, are their consent required for attendance in sex education?
for
under the
attendance. If it is going to be part of the regular curriculum, it will be treated as a regular
Now,
subject.
Is parental consent required before children are taught that sexual relations outside of marriage or absent a loving relation is good for them or their bodies? You don't know.
I don't think the RH law says that, Your
In other
Honor.
words, the Department of Education has a far superior right because it did not ask to have to ask for consent. In the public interest, this points from the public interest, over the rights of parents to the sexual education of their children that affect family values. That's your position, actually.
Again, Your Honor.
That the Department of Education has a superior right as far as sex education is concerned.
No,
than
Your
the
Honor.
parents.
In fact, what I said in my opening statement is that it is not exclusive, the right of parents. And the Department of Education
Yeah,
is
that's your
simply
point.
through
That's
the
what I'm
public
saying.
curriculum. Yes.
Well, I'll go to another point. I call your attention to section 23,
23.
paragraph A, number 1 of the RH law. it prohibits healthcare service provider from intentionally providing incorrect information regarding programs and services on reproductive health, correct? Is that correct?
Yes, Your Honor.
In this connection, Section 9 of the same law states that hormonal contraceptives and IUDs are safe. Yes?
No, Your Honor.
So, Section 9
That is not what Section
states
9
that
says, Your Honor.
hormonal contraceptives and IUDs are safe because it's safe like the other things. It says. So it does not say that.
It does not say that, Your Honor.
So
That
what
is
does
a
it say?
conclusion. Let me read, Your Honor, Section 9. The National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortifacient, and effective family planning products and
So
supplies.
from your point of view, that does not say that hormonal contraceptives and IUDs are safe.
No, Your Honor. It simply reiterates the function of the FDA, right, to ensure that
So I will tell you, from the
hormonal
point of view of the
contraceptives
law,
are safe, legal, and non-abortifacient.
so I'll ask you directly, from the point of view of the law, are hormonal contraceptives and IUDs safe?
That is for the FDA to determine, Your Honor. What the law is saying is simply
Does
only...
the law say? I know. I'm looking at the law, and I've not found there a provision that says that the Food and Drug Administration is the one to determine whether they are safe. Only
I'm
they
sorry,
are
Your Honor.
not
There is a
abortifacient,
council.
but rather whether they are safe. That's not there.
No, Your Honor. Let me correct myself. There is a council, apparently, that determines what types of drugs go into the National Drug Formulary. And it is that council that determines whether or not they will be included. But the FDA also, Your Honor, has the function to determine which types of drugs are safe, legal, and non-abortifacient. In fact, this statute imposes the obligation on the FDA to ensure that hormonal contraceptives and IUDs are safe, legal, non-abortifacient. And that is because there are already, as was mentioned by
how is
Senator
it now?
Pia
Where does
Cayetano,
it stand? Well, assuming it's FDA,
it provides a
does
standard.
it provide are hormonal contraceptives and IUDs safe?
I
As
think,
far
Your
as you
Honor,
know.
that is the wrong question for purposes of
No,
reading the
you said that the
statute.
FDA has looked at it. That's the position of the government?
The position of the government, Your Honor, is that Section 9 creates a standard.
No, I'm asking you whether it's true that hormonal contraceptives and IUDs are safe.
If they are allowed by the FDA.
And
Because the FDA, Your Honor,
So I ask
is
you, have they allowed by the FDA?
They have been allowed by the FDA,
okay.
Your Honor.
So-
If
so
I
they
may
are
tell you, Your Honor,
so they are safe.
hormonal contraceptives and IUDs are already available in the private market ever since
All right,
1966.
so based on
Since
official...
1966, they
So-
have been allowed in the private market,
All right,
Your
so
Honor.
based on official position, these are safe.
Those that have been allowed by
Are
the
safe.
FDA.
Okay, now. So if a doctor tells his patient exactly the opposite,
Okay.
namely that these things that were approved by the FDA are not safe, in their honest professional opinion, the doctor will be giving the patient an incorrect information?
The statute says knowingly withhold
Well,
information.
he knowingly.
or restrict.
He knows that the FDA ruling is that it is safe, but he says in his opinion it is not.
Then that is his opinion.
So, well, will he go to jail for it?
Of course not. He's
No,
making
he
an
tells his
opinion.
patient. That's what the government says. Well, which one is the correct information? What the FDA says or what the physician says? They are opposite positions.
Your Honor, when the FDA says it is safe, that means it can be used. That based on a risk-benefit calculation that they have made, it can be used for private purposes or public
So
purposes.
the doctor,
in the same way, Your Honor, that
so
it is
the doctor
available
will
in the
not go to
private
jail
market.
for saying that they are not safe.
If in his opinion, it is not safe because the risk-benefit for purposes of application to a particular person is
No,
not safe, then
somebody
that
just asked, he's not examined him yet, but consulting him, and he says, I do not consider that safe for anybody. Will he be liable under this law?
I don't think so, Your Honor.
But so that information that he gives is correct information.
That is opinion, Your Honor. This refers to information. It has to be factual.
Information.
If he says that the FDA is wrong, then he can be subjected to prosecution because he's going against the official statement
so
of the
if a
FDA.
physician disagrees with the finding of the FDA, he will go to jail and tell his client his patient about it. He will go to jail.
Allow me to read you, Your Honor.
No, that's
the
what you're
full
saying.
Statement. Okay.
That's what you're saying.
What the RH law, section 23, paragraph A, number 1, prohibits.
Don't go to that. I was asking
Knowingly
you-
withholding information, restricting dissemination, intentionally providing incorrect information regarding programs and services on reproductive health. That is his opinion with respect to hormonal contraceptives, Your Honor. Nothing to do with
he disagrees
programs
with the
and services on reproductive health, including the right to
FDA.
informed choice.
He disagrees with the FDA and tells point blank to somebody ask him and says, no, I disagree with the FDA. Those contraceptives are not safe.
In the course of a patient-client doctor-client relationship goes against the finding of the FDA, then I would say the prosecutors can think about it.
So that makes this law vague. If people have to, by just reading it, will not be able to know whether a crime has been committed or not.
Your Honor, that's a problem with the facial challenge. We are in the realm of speculation. We're looking for ways to find the law unconstitutional. And I don't think that is the function of the court. The function of the court in a facial challenge is look simply at the correspondence between the text of the Constitution and the statute.
All right. My recollection is that both
Your Honor, your concerns are appropriate for an as-applied challenge, which has no
Let me ask-
preclusive
let me
effect
ask
on
you-
the dismissal of
Let
these
me ask you
cases.
another question. My recollection is that both Congressman Lagman, correct me if I'm wrong, and the Universal Healthcare Study Group, on whose paper Congress relied on, according to you, hold the view that life of the unborn child begins only from the moment of implantation of the embryo on the uterine wall. Is that view correct or incorrect information under the law?
Insofar as a doctor-patient relationship is concerned, I don't even know how that would arise, Your Honor, in a doctor-patient relationship.
No, it will matter because abortion is prohibited, and if they opinion
And the
is that there's
statute
no abortion
is
before
clear about its
implantation of the
policy on
uterine,
abortion.
that
Abortion
makes
is not
That
allowed.
makes a difference in my mind.
Your Honor, the statute is very clear.
So you don't know the answer. No, you just tell me if you can answer it or not. I'll be contented if you cannot answer it.
What I'm simply saying, Your Honor, is that the statute is quite clear.
Now, many Catholics tell us that contraceptives kill the unborn that God creates out of His own image. Would you consider that an incorrect information?
Your Honor, that is a valid statement by a citizen because a citizen
I'm
is
not asking
entitled
you
to
if
free
it's a valid
speech.
statement. I'm asking you if under the law that constitutes incorrect information if a doctor tells that to a person seeking help.
Again, Your Honor, I want to hear your question again, Your Honor, if I may.
Many Catholics say that contraceptives kill the unborn that God creates out of His own image. Would you consider that an incorrect information from the point of view of this law?
I would consider it, Your Honor, a citizen's opinion.
Not information, no, but
Yes, of course.
But it's a doctor
citizen,
saying-
Your Honor, is entitled to a wrong opinion.
well,
That
so
is
it's
called
an
free
opinion.
speech.
If a doctor tells that to his patient, it's a neutral opinion. So there's no crime committed.
The requirement, Your Honor, is for the doctor to provide access to RH information and services. If the doctor is
No, I'm just telling you
a
this.
dogmatic
I'm
Catholic
limited to
or
this
a
particular.
true Catholic, then
Don't
his
go into that.
obligation
I'm
is to
limited.
conscientiously object and refer.
I'm limited to this particular circumstance or situation.
But, Your Honor, we cannot invent factual situations just so we can find some
We're not inventing.
unconstitutional portions in the statute.
evidence,
This
you
is
can
a
ask
facial
hypothetical
challenge.
questions. It's
And in
okay.
a facial challenge, let me just
Hey,
repeat
let me finish.
jurisprudence, Your Honor.
We can ask hypothetical questions. You know that. So that's not inventing.
In a
We can
facial
ask
challenge,
hypothetical
Your Honor,
questions
all
to
that we
check.
need to find is a constitutional application of the statute. And if the statute has a constitutional application, that is a knockout argument. Respondents are entitled to a dismissal of the opinion. If there
Yeah,
are
I know
possible
that.
unconstitutional
You've been
application of the
repeating that
statute,
argument, but
that
I
will
said-
have to be done in an as-applied challenge.
You should not have presented arguments that assume for the sake of argument that
But,
these
Your
can
Honor,
be raised here.
all our
did.
arguments have jurisdictional underpinnings. That is exactly what we have been trying to say.
That's still the issue. It's not settled here that that is the case. You know.
Your Honor,
Don't
we are
insist on
not
that.
trying to reinvent the
Don't
wheel.
insist on that because we can ask these kinds of questions because we can ask hypothetical questions and test your thesis against these hypothetical
Yes, of course,
questions.
Your Honor. And our answer always has an underlying assumption.
Yeah, we know that. No?
An
We are
argument.
aware. But
That
that
the
is
court does not
unsettled.
have jurisdiction.
We have not made a ruling that these are invalid facial challenges. We have not made a ruling.
And we agree that you have not yet made a
So
ruling.
don't
But
use
we are
that
making an
against-
argument, Your
Don't
Honor.
use that against us when we ask you these questions, because that is not a settled matter. Okay. Now, suppose a doctor reads the result of the latest scientific and medical research, and this convinces him that the government's view on artificial contraceptives is not correct. He cannot tell that to his patients because he would giving incorrect information until the law is repealed.
I think, Your Honor, again, we're speculating, but assuming that there's that kind of a factual situation, what the law generally provides is for doctors to comply with the standard knowledge of their discipline.
Well,
If they knowingly
I gave
go
you a
against-
specific, don't stray away. I gave you a specific situation. I know those general principles. I don't need that. I'm giving you a general situation, a specific situation, and I'm asking you whether that constitutes incorrect information. You can tell me it's not, or it is.
Your Honor, that would depend on the prosecutors if they want to consider it in an as-applied matter, once the law is operational.
So just from reading of the law, you will not be able to answer it.
Of course not, Your Honor.
Well, that makes that law vague. It's a criminal provision, and if you cannot answer it...
No,
in
Your
the
Honor.
case of
My
the law, that
answer
would
is
be
simply
vague.
that if any challenge will have to be made against the law, it will have to be made as applied, so that we have concrete facts involving real parties with real interests.
Right. Let us go to the conscientious objection portion of Section 23A, number 3. Except for conscientious objection, would the doctor have any valid ground for refusing to provide the services asked of him under Section 23A, number 3?
Again, Your Honor.
Except for conscientious objection. That's an exception, huh? That's an exception.
Yes.
Not, would the doctors have any other valid ground for refusing to provide the services asked of him under Section 23?
If his objection is religious, his only objection would be that of a conscientious objector.
No other valid ground. No other valid ground for
I don't know, Your
refusal.
Honor, whether in the medical profession there are other valid grounds. But insofar as
The law
religious
is
objection
concerned,
is concerned,
there's none.
the ground is conscientious objection.
Okay. The conscientious objector has, according to Section 23, the option to excuse himself from providing the health care services required of him on account of his ethical or religious belief, correct?
Yes, Your Honor.
But he must immediately refer the person seeking his services to someone else who could do it, correct?
Within the same facility or one which is conveniently
Yes,
accessible.
well, that's good. Now, suppose the Catholic religion considers it a sin, similar to murder, to implant a copper IUD into a woman, since it would kill the unborn by preventing it from attaching to a womb atrophied by the toxic substance from the copper IUD. The RH law respects the right of the Catholic doctor, in this case, to refuse to do what his faith regards as murder, correct?
Yes, Your Honor.
But he has an obligation to immediately refer the woman to another doctor who would be willing to do it for her, right?
The law refers to another healthcare service provider within the same facility or
this
one
is
which is
shortcut.
conveniently
Who's willing
accessible.
to do it? Yeah. Now, so if the law would excuse the Catholic doctor from committing what in his faith amounts to murder, would it be reasonable for the law to compel him to help the woman and show her how she can have her child murdered by another doctor?
Your Honor, you're assuming that the free exercise clause assumes that the state believes in the factual belief of, in the
that's why-
religious belief of the
That's
objector.
why the state honors that belief, because precisely the state tells him, you may opt not to do it.
Your Honor, freedom of exercise has a fundamental underpinning, and that is respect and tolerance, not belief. The moment we enter that realm of belief, we are entering a territory which has led nations
but the
to
law
war.
itself,
The law does
honor
not.
the belief here. Ano talaga yan, di ba? The law says honors the religious belief.
Of course not, Your Honor. The law says it is respected.
Yes, it honors.
But the state
it
doesn't
respects.
believe. It doesn't
What does
necessarily
it-
have to believe.
What does the law say exactly, you know?
The law uses the word respected.
Ethical or religious belief. Ano sabing walang belief na kalagay?
Shall be respected.
Oh, yes, respect. What do you mean by respect? Respect means to...
It is entitled to
honor
consideration.
it, no? Not to compel. Precisely what he says, don't do it. If you don't like it, do it. Your religion prohibits it, let somebody else do
Exactly.
it. All right, so...
But the state doesn't say we believe in what you believe, because that would be
I
a
did not say
violation
that.
of the non-establishment
I did not say
clause,
that.
which is exactly also why
You're putting
the
something
state,
into my mouth that I did not say. I did not say that the state should believe what the doctor believes. I did not say that.
but that's the
But
assumption
that
of
the
what you're
state
saying.
should honor or respect that belief. So
Yes,
that's
Your
what
Honor.
I'm saying. So what is your answer to that? That is your best answer?
There are several answers. Number one, Your Honor, this is in the context of a doctor-patient relationship. When a doctor assumes a responsibility, he has to perform the functions of that office. The conscientious objector proviso actually allows doctors to be unprofessional to the extent that they are allowed not to perform the functions of their office. As a compromise, they are given the right to refer the patient. Why? Because this happens in the context of a professional relationship.
But
If
medical-
I may give you an
you.
example, Your
I'll
Honor.
interrupt you. Medical practice, from what my understanding, is the application of the science of medicine on the patients, medical practice. But you consider rejecting a patient and telling a patient to go to another doctor part of medical practice? I wonder if you can show me a medical manual practice that says that is part of medical practice.
Your Honor, the requirement is for them to perform their medical functions, which is to provide RH
It does not
services
say
and
here.
information.
It does not say
If they
in the
have
law.
a conscientious objection to the statute, the law says they are excused, which is a grave concession
So-
on the part of the state.
Well, anyway, that is your submission.
Yes, of course, Your Honor.
Now, you cite the Ebra-Lina case concerning students who were members of the Jehovah's Witnesses. They refused to salute the flag, right? In
On
this
what
case,
page, Your Honor?
in this case, they refused to salute. That's in your comment. In this case, they refused to salute the flag, right?
Yes,
It's a very
Your
simple case. And for this reason, they were expelled from school, correct?
Yes, Your Honor.
But the Supreme Court said that the school cannot compel the Jehovah's Witnesses to salute the flag, right?
Yes, Your Honor.
That would violate, said the court, the religious belief that salutes are reserved to God, correct?
Yes, Your Honor.
The court said that the Constitution respects their religious belief not to salute the flag, right?
Respect, Your Honor.
Yes. It is the same here in the sense that the RH law actually respects the right of the Catholic doctor not to be compelled to implant, in this example, a copper IUD into a woman's womb because it amounts, according to his religious belief, to the murder of an unborn child, correct?
With one big difference, Your Honor. In the case of Ebralina, the students were being compelled as citizens of the Republic. They were being imposed a civic duty. In the case of the RH law, the minimal compulsion, which is the duty
No,
to
I'll go to
refer,
that. I'll
happens
go
in
to
the
that
context of
later.
a professional relationship.
Well, I'll go to that later, no? But as the main thing is that they were not required, the doctors here are not required to do what ordinarily they should have done. No?
They are required
because
to
of their religious belief. Now, so the Constitution and the law respects the doctor's religious belief, right?
Yes, Your Honor.
But you invoke the court's ruling in the Jehovah's Witnesses case that the school authorities are not powerless to discipline their members if they commit breaches of the peace, right?
Yes, Your Honor.
By disruptive actions that would prevent others, namely their classmates and teachers, from peacefully saluting the flag and singing the national anthem. It's all right for you if you don't want to take part, but you have to allow the
They have
others
the right to remain
to
silent,
enjoy.
Your Honor.
Okay,
Yes.
that's okay. Now, the Jehovah's Witnesses should respect the right of others by keeping quiet and not disrupting the flag ceremony. That's the ruling of the court.
Yes, Your Honor.
Keep quiet and let alone. That is the rule, correct?
Yes, Your Honor.
Now, in the case of the Catholic doctor, he should do nothing to impose his religious belief. Ayaw niyang maglagay ng ayod, it's okay. But he should not impose his religious belief on the woman, correct?
By refusing to refer.
Yes. No, not to do the
Oh, Your Honor,
implantation.
that is what the statute says.
No, I'm not going to that
He
yet.
cannot transform his religious belief to make himself a positive impediment to access to RH services and information.
But like the
And that is
Jehovah's
reasonable.
Witnesses, the equivalent conduct for the Catholic doctor, it's you required, the court requires of the Jehovah's Witnesses, is to keep quiet and let alone. But here, the law requires the Catholic doctor to take steps, positive steps, to ensure that the woman is pointed to another place where she could get the IUD implantation she wants. In effect, the law compels the doctor to do more than just keep quiet and let alone. Correct?
Wrong, Your
Not
Honor.
just keep quiet and let alone, but do something else.
This relationship, again, Your Honor, if I may, in Ebralina, the relationship was between citizen and the state. A Jehovah's Witnesses who remains silent during the flag ceremony harms no one. And so the court says you can keep quiet, but you cannot be noisy, you cannot criticize people who are saluting
said
the
that
flag or
already.
singing the national
Don't
anthem.
repeat that. We said
But in
that
the
already.
context of a professional relationship, a doctor-patient relationship, not a citizen-to-citizen relationship, that doctor has a positive duty to perform something.
He is not his patient.
But he is.
No, he just came and said, I'm not going to do it for you.
That is his duty. The moment, Your Honor, a doctor enters a hospital or a clinic, that doctor wears a hat. And that hat tells to everyone,
that's
I
a
am
new-
willing to perform my
That's a
medical
new theory
functions.
on formation of...
That is the theory of the statute,
so,
Your Honor.
parang sa lawyer, kung gano'n, pag nagpunta somebody wants to consult, he is already a client. Well, we know
Yes,
that's
Your
it,
Honor.
no?
Which is why the more appropriate analogy is People versus Judge
So
Veneracion.
that is your answer. That is
That is
the
our
kind of
best answer,
relation
Your Honor.
that we have now.
Yes.
The law compels him at the pains of going to jail get involved and help in the commission of what is religious belief regards as amounting to the murder of a child in order to satisfy the need of the woman and her partner for sex without pregnancy, correct?
Wrong, Your Honor.
That is the exchange.
Again, Your Honor, those are astoundingly wrong assumptions about the operation of the statute. The duty here is a professional duty. If I were talking to a doctor as a citizen, that person has all the right in the world to reject my request for
By the way,
RH information and service.
this
But the
referral-
moment that doctor enters a hospital, wears a hat, assumes a responsibility, the law says you have to perform that responsibility. But the doctor says, no, I'm a true Catholic. And so the statute says, we are respecting that, but because you are a professional, we're imposing on you the minimal burden to refer. That is the theory of the statute, Your Honor. Because you are a professional, we will allow you to reduce your professional responsibility by not performing the task, but we will impose on you the secular task of providing RH access to information and services.
So, unlike
we are not
the-
allowing you to become a positive impediment to the statute.
So it's a case of not just keep quiet or let alone, but get involved in something that you consider a violation of your religious faith. To help someone get help to commit the murder that the doctor will not himself commit.
That is a
From
good
his point of
opinion.
view. From his point of view.
Yes, and the state
Okay, now-
says we stop at the point
Is,
where we recognize your conscientious objector
But these
status.
referral cases are not emergencies actually, because if it's an emergency like a bleeding woman, the doctor has no choice but to give
There
medical
is an
assistance
additional
already.
provision in the
So
statute.
this is a non-emergency case. I wonder if you honestly think that a doctor should be jailed for not helping the man and the woman get worry-free orgasms.
Your Honor, my private opinion is irrelevant to the constitutionality of the statute.
Well, my final point. The law especially wants the poor to have the people full access to quality health care services, correct?
Yes, Your Honor.
In fact, Section 7 requires all government, maternity hospitals, and clinics to provide them with contraceptive supplies and procedures. Do you agree?
Not to provide, Your Honor, but to provide access if they want to.
Well, access.
This
we
is a
give it to
liberal
them.
statute, Your
How
Honor.
can
This
you
is
have
not a
access in-
compulsory
in
statute.
How can you access supplies in government hospitals if you will not be given supplies?
You have to say yes first, Your Honor.
Oh, yeah, that's right. Now, would you have an idea of how many poor women are candidates for free government-supplied contraceptives?
None, Your Honor, but I'd be willing to provide you with the numbers. in the memo.
Well, let us assume roughly 10 million, about half the probable number of women. Let's make it even, let's say, 8 million. A set of contraceptive pills costs about 500 pesos per month. That would be about 6 billion a year for just 1 million poor women.
Just 1 million poor women.
Yes, so 6 billion. Hormonal IUDs cost about 10,000 each, or about 10 billion for just 1 million poor women. The cheapest contraceptive is the copper IUD. It costs about 152 each, the price of a lunch. That would cost only 125 million pesos for 1 million poor women, and good for 5 to 10 years, according to some manufacturers. Indeed, foreign funding is available for this. Now, which of these, in your opinion, will our government provide free to poor women? Which of these kinds?
I think, Your Honor, that the government can choose to provide a full range of RH services and supplies and information. How
The answer is the 125 pesos per piece copper IUD, because in fact that is what the government hospitals where people deliver their babies.
well, that is the
actually
speculative
given.
answer, Your Honor, by
Well,
a citizen. If you want, Your Honor, we can provide you in our memo with
Yeah, you
the
give us a
numbers
memo,
by
no?
the DOH, for the DOH.
So it does not matter that according to the World Health Organization, copper IUDs steadily releases toxic or poisonous particles into the woman's womb to kill the sperm and atrophy the uterine wall for 5 to 10 years. It does not matter that these copper IUDs have harmful side effects. These IUDs are cheap now, and we are talking about the wombs of the poor women. Do you think that women of the poor have a fighting chance against the known harmful side effects of copper IUDs?
Your Honor, it's accessible even to those with money.
Well, really poor women don't have money for fare going to the doctor. Tell me, where will they get the money they need to cope with irregular bleeding during menstruation resulting in anemia, which is the common complaints on?
Your Honor, I'm not a
IUDs.
medical doctor. I don't know whether or not all uses of
I'm
IUDs
asking you
will
where the-
necessarily result in
Where the
bleeding.
money, where the oil?
All drugs, all devices
Well, you
have
should
potential
have-
side effects. And there's a statute, Your Honor, that says that the FDA is
You
put on
should have
notice with
conducted
respect
your,
to the
your
side
res-
effects of this
We expected
these
you to
devices.
conduct your research and look at it.
Well,
Now,
of course, Your Honor.
where will they get the money for vitamins? This is the women of the poor. Our target is 8 million. Where will they get the money for vitamins and medicines they need to fight anemia? Which doctor will examine them for free, give them blood tests and other procedures for dealing with headaches, inflammation, and pain in the pelvic region, abdominal cramps, breast tenderness, and vomiting?
Your Honor, I don't
They have no
think
money for fare.
hormonal contraceptives and IUDs will be distributed like candies under the statute. These are prescription materials and services. And it would be unprofessional for a doctor to stop following up with a patient.
If these IUDs, copper IUDs are not removed, their wombs, the wombs of the women of the poor, would be receptacles of poisoned copper particles for 5 to 10 years. Do you think this
Your
will
Honor,
not cause permanent injuries to those wombs and eventually cause death?
I don't think we can test the constitutionality of the statute by the standards of an unprofessional doctor. I think we have to assume that our doctors in the public and private sectors will perform their task, that if they provide hormonal contraceptives or IUDs, they
But
will
these
follow
are,
up. Because that is part of the functions of their medical profession.
But these are accepted adverse side effects of these.
Then if these are
IUDs.
accepted side
We are
effects, then
talking
the
here
doctors
about-
are put
we
on
are talking
notice
here-
to supervise.
We're talking here about targeted 8 million poor women. Would the government have the money to help 8 million women cope with side effects when in the first place it is money only for the cheapest kind of IUD and the most toxic to give to them?
Your Honor, the statute provides for full access to the full range of RE services, supplies, and information. It's not as if the only ones that will be provided will be the cheapest hormonal contraceptives and the most dangerous
The
IUDs.
government will give that. Now, before I end, may I ask Senator Pia Cayetano to check the information she gave us at the last hearing that the risk of cancer from hormonal contraceptives, grade 1, is the lowest risk and is equivalent to exposure to television, cell phone, or microwave oven, because a cancerologist told me that grade 1 is the highest risk classification for carcinogen. The exposure to television, etc., belongs to grade 2B, which means that the claim that they cause cancer has not been proved. So please include that, the result of your query. I just want to check in your memorandum. Thank you.
Thank you, Justice Abad.
Justice De Castro.
Let's go back to the duty of the conscientious objector to refer,
Yes, Justice.
which you are discussing a while ago with Justice Abad. What is the compelling state interest in imposing this duty to refer to a conscientious objector which refuses to do so because of his religious belief. What is the
Your
interest?
Honor-
What is the compelling state
Yes.
interest to impose this burden?
In the first place, Your Honor, I don't believe that the standard is a compelling state interest. This is an ordinary health legislation involving professionals. This is not a free speech matter or a pure free exercise matter. This is a regulation by the state of the relationship between medical doctors and their patients.
But,
We cannot impose the highest possible standard, because the highest possible standard in constitutional law is limited only to the relationship between the state and citizens.
If it is not the highest standard, there must be some standard that will show that the
Yes,
action
Your
of-
Honor,
that
rational
this
basis
provision-
standard.
That this provision is not arbitrary. So what is the rational basis to impose this duty to
Yes.
refer, which will impair the religious freedom of the conscientious objector?
Again, Your Honor, number one, thank you for accepting the rational basis standard. The rational basis
I'm
standard
not
is...
accepting that. I just want you
Okay.
to explain your position.
Okay. I think, Your Honor, that the rational basis standard is complied with when the state decides to say that Filipinos who are poor are allowed to have access to RH information and services. The law is right creating in that sense. It creates access to Filipinos who have the right but who don't have the choice because of their economic challenges. And I think, Your Honor, that is a rational relationship. We are providing you with this right, and this right is impaired if a doctor who is a professional refuses to perform his or her professional functions.
It's not the performance of the professional function of the doctor. It is simply referring that person whom he refused to take in as a patient to another health service provider. That is not an exercise of his professional duties as a
Yes,
doctor.
Your Honor, that is because the government already excuses the doctor from performing his or her medical function. This is already a compromise. When the government says you have the duty to refer, what the government is saying is, we are allowing you already to be unprofessional by not performing your function. But you can't be a bad person and totally refuse access to RH services and information of a citizen. You cannot transform the citizen who needs access to RH information and service into a victim.
All right. Your position is that that is a responsibility of a doctor, which you should justify on the basis of a code of professional conduct of doctors. That if he does not want to perform something, he has to refer that patient to another person, to
Your
another
Honor,
doctor.
I
I don't
Yes.
see any obligation on the part of a doctor to
The
find
The original
to find
obligation...
someone else or another doctor for that patient whom he refuses
Yes.
to take in as a patient.
Yes,
Now,
thank you,
and
Madam
it-
Justice De Caso.
yes.
The original obligation is the duty to perform right, or provide RH service and information. That is the original obligation of the medical professional. And the medical professional, because he or she is a conscientious objector, right, is allowed already by the state not to perform that original function. This is a highly reduced function. This is a minimal burden. So the state is saying, if you're not going to act professionally by not providing the RH information or service that everyone else is required to do or perform, we will impose on you a minimal burden. You're going to refer. Because otherwise, Your Honor, to not refer would be to create a victim in the form of that patient. That would be equivalent to the case of Ebralinag, someone who does not salute the flag or sing the national anthem, but disrupts the entire proceedings. So what the state is saying is, you are allowed to remain silent, but you cannot transform yourself into a positive impediment in the implementation of a health law.
Isn't information dissemination of government programs the responsibility of government and not any individual or any professional? If there is a program like this, family planning program on the part of government, isn't it the concern of the government to see to it that information is disseminated by
Absolutely,
government?
Your Honor. And
Why-
so
why
the government
impose-
here
why
acts through the doctors,
But why
the
impose-
medical professionals.
Yeah, why impose that on someone when that will go against his religious belief?
Because that
When he has
someone,
no
Your Honor,
obligation
is
to-
a public official, is a doctor who wears a hat saying that I am willing to treat anyone and everyone.
What we're talking about here is information dissemination. And so, isn't it, what I'm asking you is, I want you to explain why
Yes, Your Honor.
the dissemination of information on family planning should be imposed on a person, a doctor, who believes that this will go against his religious belief.
Yes.
This is a clash between compulsion being made by the government, however light it is, which may impair the religious freedom of a doctor.
I think, Your Honor,
You have to justify
Yes, Your Honor.
why
Thank
it
you.
should be the obligation of
yes.
the doctor
And
to
the
do
justification, Madam Justice De Castro, is this. I think the theory of the statute is that a big part of the inability of Filipino citizens to maintain their reproductive health is a consequence of lack of information. And this lack of information has a big social impact. And this lack of information is also the result of certain structural injustices in our society. People don't have the money to spend on internet so they can Google the latest information on RH. What the government does is simply providing the bureaucratic mechanism, right, so that the information which is not available to a lot of Filipinos, women, children, and males, right, will finally become available. And information that they can also totally reject. And the only way to do that, Your Honor, is through the public, the Department of Health, through its control over public hospitals and to a certain extent, private hospitals.
So you believe doctors should to keep themselves abreast of what health service provider or health service professionals are available to whom they can go to? Is that the responsibility of every doctor now, to see to it that they know where to refer these persons, even if this will go against their religious belief? Are you not imposing, is the law not imposing this undue burden?
I don't think it is an undue burden, Your Honor, because, again, it arises not in the context of...
An undue burden which a person may think to have that tendency to impair his exercise of religious freedom.
Yes, Your Honor, I am a lawyer, and therefore I don't have a duty to provide RH information and service. I can go against the RH law all the time. But if I am a doctor, I am bound by certain duties. And what the government is doing here is regulating that particular duty, the duty between the doctor and a patient. And I think there is a clearly rational relationship between the right of the state to regulate that duty insofar as ensuring that those who don't have access to information will be on a position of parity with those who actually have access because they have the money to access the information.
But look at these cases which may involve which are not emergency in nature, not emergency cases. So time is not of the essence. So if someone approach a doctor and would like to know about family planning method, the information need not be given right then and there, because this is not an emergency situation unless he wants to have to do the sexual act right after leaving the doctor's clinic. There's no such emergency situation that will compel the physician to exercise his professional duty, if you consider that a duty.
I think, Your Honor, what the statute does is to allow citizens to have access to information
Yes,
and
but that
services,
is- as
whether
I
or not
said-
it's
as
on
I
an
said-
emergency basis.
As I said, isn't that a responsibility of the government to disseminate information?
And the information, Your Honor, is being disseminated by the government through the DOH, through its hospitals, and through people who work in those public hospitals, such as doctors, nurses, midwives.
Shouldn't that be enough?
That's exactly, Your
Instead
Honor, what the
of,
government is doing.
instead of imposing a burden which will impair the exercise of religious freedom of a physician?
No, Your Honor, because if you are a public health service provider, right, you are within that governmental framework, within the bureaucracy, you assume certain responsibilities, and those responsibilities are professional responsibilities. Here, the law is already very reasonable in the sense that it respects the right of a conscientious objector not to perform that professional function. But there is a minimal burden. That minimal burden is the obligation to refer. Because otherwise, Your Honor, you are creating a victim out of a patient. A victim who spent, the only money he or she has to go to a healthcare center, right?
Isn't this like the minimal burden of saluting the flag
No.
for a few minutes when the flag, when the national anthem is being played?
In Ebralinag, Your Honor, the court actually allowed the Jehovah's Witnesses to be excused. But that burden is a burden imposed on a citizen. This is a special kind of burden. This burden arises in the context of a professional relationship. Again, Your Honor, just like in the case of Judge Veneracion, even if he were a true Catholic, true to the ideology of his beliefs, right, he is required by the Supreme Court to impose the proper sanction. What the court is saying is, regardless of your faith-based epistemologies, right, you have to perform a certain function. This is a professional duty for you.
That's different. The law imposing the death penalty has not the constitutionality of that law has not been questioned. But now we are evaluating the constitutionality of this provision of law. So we're trying to see if this will be able to surmount the constitutional objection on the ground of impairment of the freedom of religion.
Your Honor, I'm
situation
sorry
is
to
different.
disagree.
The situation is different.
The situation is different because in the case of Judge Veneracion, he actually has a stronger case. In the case of Judge Veneracion, he could have very well said, I'm being used as an instrument to kill someone by imposing the penalty myself. Here, the burden is right, simply to refer.
He has a
If we're looking for an analogy, I would say the case of Judge Veneracion for an exemption is even stronger because he's the one who's imposing the penalty himself. Here, assuming that we believe the faith claims of the religious, it's actually a lesser burden because the duty is simply to refer, not to kill.
The difference is very marked because the law there has not been questioned. The law must be applied as it is written. Since the constitutionality of the law involved in that case has not been questioned. But here, we are in a different situation. We're trying to find out if this law, which some would consider to be an impairment of the exercise of the freedom of religion, will not be considered a violation of the Constitution.
Yes, Your Honor.
There is no analogy between these two situations.
Your
All right,
Honor, I
let's
think
not-
the religious is entitled to a full exemption in terms of conscientiously objecting and not being able to refer. If the assumption of our free exercise jurisprudence is that the state will entitle the believer to a full exemption. But that has never been the case. I remember Justice Bernabe asking Attorney Liban, Your Honor, is there a difference between the right to believe and the right to act on one's belief? And Attorney Liban says yes. The right to believe is absolute, but the right to act on one's belief is subject to regulation. Here, what is being regulated is not simply the right to act on one's belief, but the right to act on one's belief in the context of a professional duty. And I think that's a very powerful distinction, Your
Right.
Honor.
Since the law does not make a distinction between a doctor in a public institution and a doctor exercising his profession in private, I think you should be able to justify why you will apply the same standard for both doctors.
Because the
One
duty
in
to
public
provide
and the other in
access to
private
RA
practice.
services information, when it arises in the context of a doctor-patient relationship, doesn't require the existence of a
Why the
public
doctor
duty or a
should
private
assume-
duty.
Why the doctor should assume a burden which is reposed on the government, which is disseminating information about its family planning program to the extent that it may impair the exercise of freedom of religion.
Your Honor,
I'm
yes.
I don't like to argue anymore with you. I raised this question for you to be able to explain this, no, in
Yes,
your
Your Honor. Thank you, Your
memorandum.
Honor. We will
Because,
explain it in our
because,
memorandum.
that's how I look at it. It seems to be that the government is imposing the burden of disseminating information on doctors, whether they are in public or private health institutions. And what can be the justification for that? To the extent that that it may impair the religious belief of a doctor who is not in a public or government hospital or institution.
Yes, Your Honor. But if I may just give you a short answer, a doctor who works in the private sphere has the full constitutional right under the statute to conscientiously object. And so that doctor doesn't have the obligation to provide RH information and service if he or she objects. The limited burden is to refer, if that doctor-patient relationship arises at all. But we will provide you with an extended articulation in our memorandum,
You should
Your Honor.
address the position
Yes,
of
Your
the
Honor.
petitioner, one of the petitioners, that even just referring to another health service provider will already be an impairment of their religious belief, because
Yes.
it will require them to do an act which they consider to be sinful.
Yes, Your Honor.
Go now to the penal sanction for intentionally giving incorrect information.
Yes.
Will you tell us the elements of this offense? It is important for the law to be clear about the elements of the offense. Otherwise, this may not pass muster a constitutional objection.
Okay. Your Honor, the elements of the offense from the statute text itself would be, number one, you are a healthcare service provider as defined under the RH law. Number two, you knowingly withhold information or restrict dissemination of that information. And number three, and or intentionally provide incorrect information regarding programs and services on RH.
From this language of the law, will you be able to know what is information that cannot be withheld and what is incorrect information that cannot be given?
Well, I can speculate on a factual situation for you, Your Honor. Someone
But
goes to
you cannot go into a factual situation. We are looking at the language of the law.
Okay, Your Honor.
The elements of the crime, of a crime or
Yes.
any offense, must be found in the law.
Yes,
not
Your
in the
Honor, I agree.
application, not in the application of the law. How can you apply the law when the law is not clear? So you have to explain to us the meaning
Yes.
or the elements of the offense here. The elements, what is meant by information, what is meant by incorrect information for one to be liable under this law.
Okay. I would suppose, Your Honor, that what is meant by information under the statute would be information regarding RH programs and services, including reproductive health, including the right to informed choice and access to full range of legal, medically safe, non-abortifacient, and effective family planning methods.
Information to be found.
In Section 1, Your Honor. In paragraph 1, item 1 of Section 23,
But
paragraph A, number 1.
You're referring to principles. I'm referring
Ah.
to the actual source of the
The
programs and the services.
The actual source, Your Honor, is Section 23, paragraph A, number 1.
Information coming from the FDA.
No, Your Honor. To provide incorrect information regarding programs and services on reproductive health, including the right to informed choice and access to a full range of legal, medically safe, non-abortifacient, and effective family planning methods.
Where can a person find this information?
The full range, Your Honor, would be in the definition of the statute.
provide this information?
It's in the statute, Your Honor.
Statute, but you are referring to programs and services. A party must know what information is referred to in this provision of law, the actual information that he is withholding, or information which is he is misrepresenting, he disseminating.
Again, Your Honor, I don't get your question.
Is this okay? I'll go direct to the point.
Okay.
Are you referring to the government sanctioned or approved information? Information about the safety of contraceptives and any other device may vary. The scientific studies may vary. And so there may not be any consensus or unanimity on the safety of a particular contraceptive device or pill.
Well, in that
So,
case, Your
in-
Honor, no
where-
one would be prosecuted because the element of the law is knowingly withholding information and providing incorrect information. If the debate is still robust, then it would be difficult to provide incorrect information because there's still a wide expanse of opinions with respect to the correctness or incorrectness of a particular information. I think, Your Honor, this would refer to settled information.
Information provided by the FDA, that was what was mentioned here in the previous oral arguments, that the FDA will be the authoritative source of what is safe, and that is what is found in the law. It is the FDA that will say that.
Yes, Your Honor.
Because it will procure contraceptive pills and devices, and therefore the FDA will be the one to decide which is safe.
Yes, Your Honor, because it is the government institution with the technical expertise to make judgments on that matter.
So any information that will go against what the FDA has declared will be a violation of
I don't think any information. I think the gist of the statute is becoming a positive hindrance to the full access to RH information or service of a citizen. I think that is the gist of the statute. If a doctor gets in the way of that access by providing intentionally incorrect information, I think the government has the right to penalize anyone who performs one's professional duty maliciously. I think it is in that context, Your Honor, that the statute was passed. Not in the context of any other theoretical or academic disagreement on RH matters.
It does not say malicious, it says intentional. What if the doctor intentionally give
Knowingly
a different information because that is what his experience and his training and education
Okay.
has taught him?
Yes, Your Honor, an important and an integral element of the statute is knowingly withholding, providing incorrect information. There has to be knowledge.
There's knowledge that the knowledge which may be considered incorrect because it goes against the information given by the FDA. It doesn't have to be malicious. The doctor may not be in bad faith. He may be honestly exercising his professional judgment that what the FDA said is, or what the
I would
FDA
disagree.
prescribed is not correct.
I would disagree, Your Honor. Intentionally providing incorrect information. You have to know the correct information for you to be able to know what is incorrect information. And you decided to provide intentionally and knowingly that incorrect information. You have two spheres of knowledge, correct knowledge, incorrect knowledge. You chose knowingly incorrect knowledge, and you provided that knowledge to someone, and therefore impairing that person's right to informed choice and access to RH services and information. I think, Your Honor, that's a legitimate subject matter for a penal sanction.
Place. Someone must decide what is correct and incorrect.
At some
So
point,
who
of
will-
course, yes, Your Honor, someone will have to
Yes,
decide.
so
In the same way that the court will have...
Under the law, it's the FDA that will decide what is correct and incorrect. And so there is
Yes, Your
there
Honor.
can be no dissent.
And
under
I have
under
no-
the law, there can be no dissent, and any dissent will be penalized as a crime.
Under the law, Your Honor, I have no problem with the FDA providing me with the standardized information with respect to the safety of certain drugs. Why? Because I'm a lawyer, not a doctor. I don't have the technical expertise to disagree with the FDA on these matters. And the judgment of the FDA when it comes to what is safe and what is not safe is very important because anyone who provides incorrect information may harm that patient.
The information here does not contemplate
What the statute provides, Your
an
Honor...
information coming from a lawyer. The information here is coming from a healthcare service provider. So
Exactly, Your
don't
Honor.
use
Someone-
don't use yourself as an example because
Sorry, Your
precisely-
Honor. Here, what is covered by the situation is the situation of someone who is in a position to know because of his or her medical training, and yet, because of that position to know, still decides to provide the incorrect information knowingly.
But
I think that is a...
but going through scientific studies, we have found varying views about the safety of certain contraceptive and
Yes, Your
other
Honor,
devices.
and we have done the same research, but we would always, I think, Your Honor, it's good policy to be very cautious when it comes to
My only point-
entering the realm of a different discipline.
My only point here is that I want to find out if the law defines precisely the elements of the offense.
Yes,
because
Your
that
Honor.
is important for this to be considered as constitutional, because it gives adequate information on one who is accused of violating the provision of the law. So that is the only reason why I'm
Yes,
asking this
yes.
question from
Okay.
you. I want to know what is correct and what is incorrect information, and to find out from you whether the language of the law is sufficient enough to inform whoever is accused that he has violated the provision of the law.
Yes, Your Honor.
That is just what
If I may, Your Honor,
that
I'd
is
like
just-
to
yes, that
to
is just
provide
what
two
I wanted to
answers. Number one, the first answer is that this particular provision of the statute cannot be subjected to a facial challenge precisely because it doesn't have any speech component. The other answer, Your Honor, is that the statute is complete and clear because generally what it does is to penalize a professional who, knowing the correct information, decides to withhold or provide the incorrect information to the possible detriment or injury of a citizen, someone who relies on that information.
There is no speech component. What conduct is being penalized by this provision?
The
of law?
conduct of withholding information or providing incorrect information.
Isn't that
Not all information, Your Honor, is speech under the Constitution. This is not political speech, Your Honor. If this were political speech, if I were talking to a friend and that friend gave me incorrect information about the standards of the FDA, can I prosecute that person under this statute? No. Maybe under some provision or under the tort system, yes. But here, Your Honor, this is speech in the context of the medical field. Not all types of information are free speech or can be subjected to the test of freedom of speech. That speech will have to be in a particular forum, a public forum. That speech will have to be the kind of speech that should be subjected to what? The freedom of the market. Medical knowledge, Your Honor, is a highly constrained information environment. You don't just say anything just because you want to act like a doctor. Doctors are highly trained, just like lawyers. They have full control over the jargon, and that jargon can be used to the detriment of the person. The general thrust of the statute is you cannot use your medical knowledge to create a victim out of an innocent patient. And I think, Your Honor, the statute is legitimate when it does that.
what is being put in issue here is the precise information that this provision of law gives to anyone who will stand accused of
Yes, sir.
violating this provision of law, whether or not the language as written is enough to inform the accused of what he is being
Yes,
charged
Your Honor.
with.
And
Now,
our answer, Your Honor.
Do you agree that compelled information is the antithesis of informed consent? Because the information here is being compelled. So no other
I don't think
dissent
so, Your
or
Honor.
no other information can be given.
Your
like
Honor.
a doctor, because
Yes.
here the government compels, there is a compulsion as to the information that doctors and health service providers will give to a patient. And therefore, this will go against informed consent. The patient is not given a full picture. There is only information coming from one side, information coming from the government. So no doctor, no health service provider can speak against it.
If
So
I may,
is that
Your Honor.
Is that informed consent?
If I may, Your Honor, the government does not have the right to tell me as a citizen whether or not Marxism or libertarianism is correct. But the government certainly has the right to compel doctors to comply with the standards of their discipline. Whether or not antibiotics work one way or another cannot be subjected to free speech, Your Honor, because that discipline is a highly constrained discipline. They can determine whether or not which standards of practice is violate or are violative of the standards of their profession. This is not a matter of political theory. This is not a free speech matter, Your Honor. This is a matter that can affect the health of a citizen who doesn't
Precisely.
know any better.
We are past the issue of free speech. We're now
Okay.
in the issue of informed consent.
Okay.
So so don't digress. Don't digress from the issue at hand. What you're being asked is whether or not the compelled information coming from the government is not contrary to the informed consent that is needed to protect the health of a mother.
Your Honor, if someone doesn't agree with what the government is saying, the standards of the FDA, right, all that medical practitioner will have to do would be to raise his or her conscientious objector status and refer that patient to another person. That is the reasonable, in fact, the rational way for that doctor. What the statute is saying, you cannot use your standing, your position as a medical doctor who has the authority, some level of authority over a patient, and maliciously use that to provide incorrect information on the patient, because that information may be used to the detriment of a patient.
Don't inject the term malicious. We're not talking about malice here. We're talking about correct or accurate information.
Your Honor,
We did not mean-
knowingly
excuse me.
withholding.
Yeah,
Sorry, Your Honor.
willingly withholding or intentionally giving incorrect information. Intentional is different from malicious. As a lawyer, you know that. These are two different things. I may intentionally tell you this because I believe that this is correct. But you cannot say that I'm doing it in bad faith. That is a state of mind. Intention is different from malice. So let's not confuse the two terms.
Okay.
All right. Now,
If I'm... okay.
so we're no longer, we're talking about informed consent. And that is
Okay.
what I'm asking you. Now, if a doctor sincerely believes that what was provided by the government is not safe, is it ethical for that doctor to still let someone to go to another doctor who will prescribe that medication which he believes is harmful to the health of that woman? Is that what you want that doctor to do? You want the doctor to refer, just like a conscientious religious objector. If he believes that is wrong, that is morally wrong, or if the doctor believes that is scientifically wrong or unsafe, you want that doctor to still refer that patient to another who will prescribe the same medication which he believes to be unsafe?
Your
Why
Honor,
will you, is that not unethical? Is that a violation
if I may,
of the
Your Honor,
code of conduct of a
I wouldn't want my doctor to exercise his profession on the basis of belief. I would want my doctor to exercise his profession on the basis of knowledge.
Don't mislead. We are not talking about a doctor prescribing something which is based on his religious belief. That's another matter. What I'm saying, I'm just making an analogy.
You're referring to ethical beliefs, Your Honor.
I'm referring to an analogy that between these two situations, a conscientious objector who believes that it will be against his religious
Then that is a
conviction.
conscientious objector
Yes,
on
that
the
is
basis of...
different. That's different. What
Okay.
we're talking about now is a doctor. A doctor, based on his experience, based on his extensive experience and his knowledge that he acquired by conscientious study and training, if he believes that a device or a contraceptive pill that is being disseminated by the government is harmful, you want this doctor to still refer that person, that patient, to another who will prescribe the same medicine or device which he considers to be unsafe? You think that is right thing for him to do?
Your Honor, a doctor who, based on his medical experience, believes that the government institution, with all its expertise, is wrong, is not necessarily right. Just because you believe that the government information that hormonal contraceptives, a particular type of hormonal contraceptive is safe, doesn't make you right. And so the compromise is, if you have an ethical objection with respect to the use of a certain RH supply or certain RH information, then don't be tyrannized by your own belief. You have the duty to refer. I think that's a good compromise, Your Honor.
Even if it goes against the professional judgment of a doctor, I'm referring here to the free exercise of a doctor, of his profession, the use of his professional judgment. Just like us lawyers, we have different ways of looking at things. And
Yes, Your Honor.
a doctor may have a different diagnosis of a patient who may...
Yes, Your Honor, but...
because you cannot apply the same medication
Yes.
to everyone. Every person will have a different psychological,
Yes,
or
Your Honor, but
physiological or physical makeup.
just like lawyers, Your Honor, who
Yes.
will have to comply with the existing jurisprudence of the Honorable Court with respect to how to file an appeal, what kinds of petition, the periods for complying with certain requirements, medical doctors will also have to comply with the minimum standards of their profession.
The rulemaking is the concern of the court. The court set precedents. The court set the rules for court procedure. But so what we're trying to find out is a similar authoritative source or agency which can really provide unquestionable guidelines as to what is safe and what is good for each and every person. So
That, Your Honor, would be the FDA. If it's the Supreme Court in the case of the reading of the Constitution, interpretation of statutes, creation of rules, the analogous institution, I would suppose, would be the FDA, because the FDA is statutorily charged and has the institutional expertise to determine what is safe. And we have to rely on that expertise because there's no other institution we can rely on. At some point, we have to rely, in the same way that at some point we have to rely on the decisions of the Supreme Court.
and the exercise of the practice of medicine is very different from the practice of law. There are marked differences between the two, and scientific studies may contradict each other, and there may be no one that can really choose which between the conflicting scientific studies or opinion is correct.
Then in that case, Your Honor, a particular accused would not be convicted, because if the information is, the debate is still robust, then you cannot charge that person with knowingly providing incorrect information. Because for you to be able to charge and convict someone with knowingly providing incorrect information, that person must first and foremost know what is the correct information. And if based on your example, the information can go either way, there's still a debate, then there's no way you can charge and convict someone with knowingly providing incorrect information.
Go either way, but the FDA may have that authority to say, this, we choose this side, we choose this opinion, and that is it. There will be no dissent.
Again,
that
Your
is
Honor,
what, that is,
we cannot test the constitutionality of the statute on the assumption that government institutions will act unprofessionally or go beyond or even against the bound and duty of these institutions.
That's not the point. We're still, what I'm trying to point out only is that you should be able to show to us that the information mentioned here is enough to apprise an accused of the nature of his violation. Because the law does not say what is this information that should be considered correct or incorrect.
Your Honor, I would suppose that the ultimate test for determining the content of the statute, whether or not it's vague enough, would be in an as-applied challenge, when you have a real accused who has the interest in defending himself or herself. That is the time for us to determine whether or not the law is actually vague.
Right, but you need to point out the
Yes, Your Honor,
elements,
definitely we will do that in our memorandum.
No, I'm not arguing with you. I just want you to bring
Yes, Your Honor.
out
Thank you,
these
Your Honor.
issues in
Yes.
your memorandum. Now, what about the requirement that there should be a certificate of compliance
Okay.
that a couple went through before they can be given a marriage license?
Yes, Your Honor.
Is this not a burden imposed on, an undue burden imposed on couples who would like to marry? What is the state interest here that is being served by requiring this certificate of compliance?
Your Honor, I think the state interest is clear to provide information, again, which may be rejected by the prospective couples on matters involving responsible parenthood, family planning, breastfeeding, and infant nutrition. I think the understanding, Your Honor, is that some Filipino couples or prospective couples go into marriage with little or insufficient or even incorrect information about responsible parenthood, family planning, breastfeeding, and nutrition. This is a rather benevolent government program to try to provide them with the opportunity to learn about the burdens of parenthood. And this opportunity is in the form of an information which, again, they can totally reject. And so I think, Your Honor, this is a very reasonable mechanism.
But they are compelled to go through this process before they can be issued a marriage license.
Yes, Your Honor.
Is
But
this an imposition on the exercise of the right to marry?
no, Your Honor, because this is not a substantive qualifier. Right? It's not like an age requirement or a property requirement that goes into the right of a person to marry. This is an administrative requirement, Your Honor. And there's a reasonable relationship between this administrative requirement and the interest of the state in ensuring that prospective spouses, future families of the Republic will have an opportunity to acquire sufficient information on responsible parenthood, family planning, breastfeeding, and infant nutrition. Again, Your Honor, bottom line is if they want to reject this information, they can totally reject it.
Now, why is it that the consent of the husband is not needed where one would like to avail of the family planning methods provided by the government?
No, Your Honor, I think that applies to procedures, not information. I suppose, Your Honor, you are referring to Section 23, paragraph 2I of the statute, which prohibits the refusal to perform legal and medical safe reproductive health procedures and the spousal consent requirement in the case of married person. What the statute is simply saying, Your Honor, is that at the private level, spouses can agree on who has the authority to have a legal and medically safe reproductive health procedure. But the level of the statute, in case of disagreement, the decision of the one, whether the male or the female, the husband of the wife, or the wife undergoing the procedure shall prevail. It simply recognizes the right of the individual to some form of sovereignty over the bodily integrity of that person, whether it's the male or the female.
Don't you think procreation is the equally the concern of the husband and the wife, and this will be more inconsistent with the constitutional principle about the value of the family, value of marriage, and the family?
I think, Your Honor, that is one view that can be held by a citizen. It is within the range of legitimate constitutional concerns. But if there's a couple out there who believes that they don't want to have children, then they are constitutionally entitled to that opinion as well. But if a couple believes that procreation is the primary goal of their relationship, then they can actually do that here, Your Honor.
The consent of either one of the spouses is not necessary if one would like to
In case of
avail
disagreement.
The reproductive health procedures.
No, Your Honor, because I think this is simply a constitutional recognition of the right to liberty of a person, whether the husband or the wife, to his or her bodily integrity. Marriage doesn't give you the right to transform your spouse, whether the husband or the wife, into an instrument for procreation. I think that's the basic rule. This will have to be done at the level of consent. If both of you believe that you should have a no vasectomy or a no ligation policy, the Constitution respects that, Your Honor. You can have as many children as you want. You can, frolic like rabbits if you want. But the law says, in case of disagreement, if there's a disagreement between the husband and the wife, with respect to legal and medically safe reproductive health procedures, then it is the person whose body is concerned that will have the choice. And I think, Your Honor, that is a reasonable statute.
That's the second part of the provision. But
Yes,
the
Your
first
Honor.
part would mean that one can keep it a secret from his or her spouse if he wants to have this reproductive health procedure. That is the main idea here. It is the sole decision of one of the spouses to avail of these reproductive health procedures secretly without the knowledge of the husband or the wife.
I wouldn't couch it in those terms.
Yeah,
I
that's
think
the
the statute allows it, but that is not the main thrust of the law.
First part. The last part is only refers to a disagreement.
Yes,
And there
Your
will
Honor.
be no disagreement if this is kept secret from the other spouse.
no. Your
so
Honor,
these are
yes.
two different situations. One, the availment of the reproductive health procedure is kept secret, and that is allowed by law because the law says that a doctor cannot refuse because the other party or the husband or the wife has not given his or her consent to this procedure.
Okay.
So it's keeping it secret. Do you think that is consistent with the constitutional provision about marriage and raising a family?
Your Honor, I think keeping it secret is something that is allowed by the law, but that is not the thrust of the law. The thrust of the law is basically a non-discrimination norm. What it says is a healthcare service provider, whether public or private, who shall refuse to perform legal and medically safe reproductive health procedures on a person of legal age on the ground of lack of consent or authorization of the following persons. Spousal consent in the case of married persons. That means, Your Honor, simply that a public health care provider who can perform this legal and medical safe procedure cannot require of that person authorization from the spouse. That is simply what it means.
Which effectively would allow that spouse to keep it secret.
It allows the spouse to keep it secret, but that is not the main thrust of the statute. It is an option available, right, for that spouse to do it. If it's the husband who wants to have ligation without the knowledge or consent of the wife, then that can be done.
This is like
But that is not the thrust.
This is like a double-edged sword. When you see one side, but you fail to see the implication. That will be the implication of this provision of law.
I think, Your Honor, that the goal of the law is to respect the privacy of the spouses. That in a wide range of factual situations, the husband or the wife who wants to have a safe and medically safe procedure will inform the other spouse. But there's no compulsory system for that in this case, because the Constitution simply respects the privacy rights of the spouses to determine the kind of relationship they want to have. If the relationship between the spouses is healthy, I would assume, Your Honor, that the husband or the spouse who will have the vasectomy or ligation will inform the other spouse out of respect, out of a sense of obligation or duty. But the law covers a bottom line situation where if the spouse concerned doesn't want to inform, or if she informed or he informed the spouse and that spouse disagrees, then the law steps in and says, it's your body, you have the right to undergo that safe and legal and medically safe reproductive health procedure. I think that is reasonable, Your Honor.
This principle is found in other legal systems where a full autonomy or full control and disposition over one's body is allowed. Now, what I want to find out is how you would relate this to the provisions of the Constitution on marriage and family, whether keeping secret a matter of procreation to a matter which affects procreation from the other spouse can be considered constitutionally infirm or constitutionally valid. You
Yes,
deal
Your Honor.
with that. I can understand why. What is the basis for this provision? Because I've read this in other articles.
Yes, Your
where
Honor.
where they do not have a similar. The legal system is different from ours.
Yes, Your Honor.
They have a different constitution, but our constitution is very detailed. It
Yes, Your Honor.
touches on so many subjects.
Yes, Your Honor.
And we cannot just import ideas from other legal system without taking into account our constitutional principles.
Yes, Your Honor.
So
And
I
I
just-
think, Your Honor, if I
just
may.
want to find out. I'm not trying to argue with you.
Yes,
or-
Your Honor.
I'm
Thank
just
you.
pricking your imagination and pointing
Your
out
Honor.
to you what are these issues that are bugging me and which I want you to explain in your
Yes.
memorandum.
Yes, Your Honor.
Because if I write my opinion on this and without giving you the opportunity to express
Yes.
is your refutation of that
Yes, Your Honor.
position.
If I may, Your Honor, just articulate, I think, the theory behind the statute. The basic idea, I think, is the assumption that the state cannot compel spouses to have healthy relationships. It's up for these spouses in the private realm to develop a working relationship. And so almost all the time, most of the time, the state actually respects that kind of a relationship. But in case of a conflict, Your Honor, this is a conflict situation where there's a disagreement with respect to access to legal and medically safe reproductive health procedure. What the law says is we will respect the right of the person who is undergoing that procedure, whether it is the husband or the wife, to have that procedure. Why? Because it is his or her body. It is a gender-neutral statute that simply respects the right of a person to bodily integrity. And I think, Your Honor, that is rather reasonable.
You're on the second part of the law, that provision of law. I'm referring to the first part about the secrecy of undergoing this health procedure. And so you cannot go to that realm of disagreement because how can someone disagree
I
with
would-
something which he or she does not know?
I would
So
assume, Your
that's-
Honor.
That's the.
Yes, if I may
I have no
respond.
problem about
Yes.
disagreement.
Yes.
I, the, the, the provision that I want you to explain is that provision which will allow one of the spouses to keep secret from the other spouse that he will undergo a medical procedure
Yes.
that will prevent
Your Honor, if I may,
pregnancy.
I think the thrust of the
between
statute.
spouses taking, if a woman takes contraceptives without informing the husband, that is a sign of
Your Honor, that is
dishonesty.
not-
That is not good.
That is
for
not
the
covered by
relationship.
this particular provision because this provision covers legal and medically safe reproductive health procedures. And I think this particularly refers to vasectomy and ligation. The thrust of the law is not to promote a culture of secrecy, but to disable a public service provider from requiring an authorization prior to performing legal and medically safe reproductive health procedure. It doesn't have anything, Your Honor, to do with the use of contraceptives because this particular provision refers to legal and medically safe reproductive health procedures. And I was informed that this refers
that
to...
is a way not to keep the other party uninformed about what's going on. That is the provision that will excuse a party from securing authorization or consent from the other party will enable that party who wants to avail of this procedure to keep it a secret from his or her spouse.
It's an option, Your Honor, that is
the
available.
Effect. That is the effect.
I wouldn't say it is the
implication.
intended effect, Your Honor. I would say it is an option available because the government basically respects the privacy right of the spouses to what? The legal and medically safe reproductive health procedure. If a spouse wants to keep this secret, the government is not making any moral judgment on the health or the quality of that relationship. It's only looking at whether or not that spouse, whether the wife or the husband, has that particular right. And the government's answer is yes. On the ground that authorization requirement is not allowed under the statute.
I said we should gauge this on the basis of the provisions of the Constitution.
Yes, Your Honor, we will do that in our memorandum. Thank you, Your Honor. Yes.
Justice Velasco.
Counsel, please have your drink first.
Thank you, Your
I
Honor.
would like to seek some clarifications on the law, Counsel. What are the departments under the executive branch that are involved or have certain duties or functions under the law?
I think, Your Honor, the statute refers specifically to the DOH as the central agency involved in the implementation of the statute. I would assume, Your Honor, that the FDA is also involved. The PhilHealth is already involved. Basically, all those government agencies that have something to do with health.
So can you say that DILG and Department of Education have certain
Yes,
participation
of course, Your
also
Honor.
under the law?
The DepEd, specifically under Section 14 of the statute, has a particular role in the implementation of the statute.
The nagging question to me is whether really there is a need for this law. So can you tell me what things the Department of Health, the Department of Education, or the Department of Interior and Local Government can do under the law, this particular law, which it cannot do under the administrative code and other related laws? Can you tell me clearly, why do we need this law?
Well, in the first place, Your Honor, I think that is a legislative judgment, not a constitutional matter. I mean, just a manifestation. But if I may provide you with an answer, I think the law is an institutionalization of what the government can in fact do. Right? So it institutionalizes certain mechanisms, such as access to reproductive health and information, age and development
Excuse me, why don't we limit ourselves first to the Department of Health?
Okay.
Because I guess that particular department has several functions or duties to perform under the law. So limit your discussion first to the Department of Health.
Okay. Because the statute makes the Department of Health, I think, the central agency for the implementation of the statute, basically what the government is doing here is focusing some of its resources, right, towards complying with certain social concern, reproductive health, and information. There was a political judgment on the part of the legislature that information is a social concern. Access to reproductive health devices is a concern. And so they have tasked the Department of Health to perform, to focus its resources on responding to these concerns. Justice Carpio, I think, has also mentioned that there are Millennium Development Goals that will have to be complied with. And so this statute institutionalizes a concern for a particular social welfare program, which is access to reproductive health and ensuring that parents will become responsible.
Okay, I'm sure you're aware of Title 9, Chapter 1 of the Administrative Code on Health, correct? You must have read it, no?
Maybe
Okay.
at some point, Your Honor.
Yes, under Section 3, Item 2, it says the department shall provide for health programs, services, facilities, and other requirements as may be needed, subject to availability of funds and administrative rules and regulations. So in short, some of the duties and functions assigned to the Department of Health under the RH law are already encompassed under Item 2, Section 3 of Title 9, Chapter 1 on Health under the Administrative Code. What I'm saying is that the DOH can do the things that the RH law is requiring it to do under its provisions. And this may just be a redundancy. It can do these things even without those particular provisions which impose certain duties to the Department of Health. What do you say to that?
Not necessarily, Your Honor. I think the RH law is a partnership between the Congress and the Executive Department with respect to providing a special emphasis on reproductive health and responsible parenthood. It may be that under the Administrative Code there are general statements with respect to what the government can anyway do under the RH law, but I think the RH law provides a specific emphasis, right, on this particular concern because there is a legislative finding that we need, or Philippine society needs to focus on these particular matters. And I'm sure, Your Honor, you realize the impact when the legislature throws its weight on a particular social concern. The legislature has control over the budget. And therefore, the RH law institutionalizes, I think, the triggering of the budget system for purposes of maintaining society support for reproductive health and responsible parenthood. If it's only at the level of the admin code, I think the thrust is at the level of the executive. And executive departments may have different precedents with different concerns, with different political calculations to make. And so this, I think, basically ties the legislature to a social welfare program that we will do this on a regular basis, not on an ad hoc basis, which I think was or may have been the experience in the past.
Do you know what is the present policy of the Department of Health on contraceptives?
I wouldn't know, Your Honor.
You don't know of the existing policy or program or projects of the DOH on contraceptives at present, even without the application or implementation of this law?
As a constitutional matter, Your Honor, I can provide you with an answer. As a constitutional matter, I would say the Department of Health can provide contraceptives on the ground that RA 4729 already exists. Meaning what? That contraceptives are legally available and may be accessed. And that debate over access to contraceptives is long over. That ended in 1966 when that law was passed. But I think the problem, Your Honor, is that even with the legality of contraceptives, the availability of its access, there is, because of structural injustices in Philippine society, a disparity with respect to choice. That those who can afford have actual choice, but those who cannot afford effectively don't have the choice. It's like having the right to buy a Volvo, but not having the money to buy that expensive car. And so I think because contraceptives are legally available in the market, the DOH can in fact spend part of its budget on the use of contraceptives. And they can put it in their budget, submit it before the Congress. I think the beauty of the RH law, Your Honor, is that you have a legislative weight attached to this particular social concern. It's an authorization on the part of Congress, right? Basically saying that we're partnering with the Executive Department when it comes to the possibility of using government funds for contraceptive use, among many other things.
The law does not explicitly set aside a specific amount
Yes, Your Honor, that's
for
true.
the operation and implementation of the RH law, right?
Yes, that
Unlike
is true.
other laws which explicitly provide a certain amount for the implementation of the law, this particular law does not state any specific amount.
That is true,
correct?
Your Honor. That is true.
And would you admit that even without this law, the DOH can ask DBM and Congress for a certain amount of money that will cover any policy or program or project which it may implement with regard to the contraceptives and the reproductive health programs?
That is true, Your Honor. Nothing prevents the DOH from asking. But I think it's a different matter when the DOH is asking with the backing of a statute such as the RH law.
Okay, one last clarification. Under Section 23, these are the prohibited acts. It starts with letter A. Any healthcare service provider, whether public or private, who shall, etc. So it lists down the prohibited acts. Can you please define to me what you mean by a private healthcare service provider?
I would suppose, Your Honor, that a private healthcare service provider is a healthcare service provider that is not part of the government institution system.
Good definition. But what do you mean by healthcare service provider in the first place?
Healthcare service provider, Your Honor, I think is defined under the statute.
Letter N. Letter N of Section 4. But it speaks
Yes.
of a public healthcare service provider.
Yes, Your Honor.
How about the private healthcare service provider? Since it is
By-
provided under the law that private healthcare service provider will be charged for commission of the prohibited act. So what explicitly does it mean under the law?
I suppose, Your Honor, by elimination, anyone who doesn't fall under the definition of a public healthcare service provider, if that institution or person provides healthcare service, would fall under a private healthcare service provider.
Don't you think that's big, and that will be reason for private medical practitioners to raise some complaints about the vagueness in the law?
I think, Your Honor, the fact that they are not defined under the law or that they are defined by implication or elimination is not a ground for questioning the constitutionality of that law.
Okay.
Private healthcare service providers, I don't think have a constitutional right to be mentioned in the RH law.
So if you're a legal practitioner and a certain law that requires free legal aid and says you don't provide this legal aid service and you're liable, you won't even complain and
Your
raise
Honor,
a question on the implications of this, what seemingly appears to be a vague provision of law?
No, Your Honor.
won't.
The RH law doesn't compel them to provide free legal advice. It gives them an option to provide free
It's the
legal
RH law. I'm not saying the
Okay, sorry.
practitioner.
Okay.
It is with respect to this private healthcare service provider that I'm worried about.
Yes, Your Honor.
Because if you're saying that they have certain duties to perform under the RH law, then they should be made aware what they're supposed to not to do, and within the realm or the scope of the law itself. That's why I'm asking you this
Yes.
question, what it really means.
Yes, I think, Your Honor, there are provisions of the statute that sufficiently make a distinction between private and public healthcare service providers, specifically with respect to, say, conscientious objector and the requirement to provide RH care services. The requirement to provide RH care services is mandatory for public institutions. It's not mandatory for private institutions, but only to paying clients. I think that is what the statute provides. With respect to providing information, a public healthcare service provider will have to provide that information because that is his or her public duty. But a private healthcare service provider can raise a conscientious objector. If she wants to provide RH care service or information, what she can do is ask for an accreditation with the PhilHealth so that I suppose she can ask for a reimbursement. I think they are sufficiently mentioned in the statute, Your Honor.
One last point. Will you please tell us why a public healthcare service provider will be meted penal sanctions in case they commit any of the prohibited acts? Or putting it another way, is this provision necessary if it involves the public healthcare service provider? Because we have sufficient laws on the reliction of duty, nonfeasance, malfeasance, misfeasance, and don't you think that these penal sanctions or penal provisions are taken care of by other existing laws and that we don't need this? And furthermore, don't we have a presumption of regularity in the performance of the functions of the duties of a public official or employee? Based on those two things, can you tell us
Yes.
what's the reason why we still have these provisions on the prohibited acts and the sanctions to be imposed on these acts?
I think, Your Honor, the idea behind the statute to penalize certain acts is, again, a recognition that there is a special concern on the part of the government with respect to promoting reproductive health. And therefore, given the special concern of the government, they decided, the legislature and the president decided that there should be some RH-related offenses. And whether or not it's redundant, I don't think it's a constitutional matter, Your Honor. But I think the basic philosophy is RH is a special concern for the state at the moment, and it has the legislative discretion to penalize certain RH-related violations.
Suppose a particular act on the part of a public healthcare service provider involves refusal to perform the duties or whatever procedures they're required to undertake under the law. Will they be charged? Will they be criminally responsible or liable under the penal provisions of this RH law and also under the Anti-Graft and Corrupt Practices Act and also under the revised penal code? Will this single act be susceptible of being may possibly result to charges under this law and the other existing penal laws?
I suppose, Your Honor, that would be a good constitutional law question, whether or not a particular act would, that may result in various types of responsibilities violate a person's right to, say, double jeopardy or due process rights, Your Honor. But I suppose as a general matter, a violation of a specific provision of the penal sanction of the statute may create different types of liability. But that would be a matter that is as applied, Your Honor, not a matter that should be subjected to facial scrutiny.
Madam Chief Justice.
Justice Perez.
May I just summarize from what I learned from the discussions from the question of justice test, Justice De Castro, you enumerated the elements of the prohibited act that you were discussing before.
Yes,
and
Your
it came to the point that what is correct or incorrect. And she wanted a definition of what is incorrect. And while not directly, I think that you implied that it is the FDA which is going to determine what would be the contraceptives that are safe. And therefore, there can be no information that would go against such an information. I know that this act allows or provides for an IRR.
Yes, Your Honor.
And that would give the FDA the first, is there already a list of the contraceptives which are considered as safe?
Yes, Your Honor.
And is a possibility that there may be other drugs which may be considered safe, as well as the possibility also of other drugs being removed from the list.
Yes, Your Honor.
Would that be allowable? Because I have doubts whether the definition of the prohibited act is complete as it now lives after, let's say, we decide on its constitutionality as it is implemented. The question being, can the definition of the crime be delegated to an administrative agency? Can the definition of the crime, of what is a crime under this act, be delegated to the administrative agency, the Food and Drug Administration?
Your Honor, I think the basic doctrine is that it is the legislature that defines the statute.
Yes, but as it is incomplete because you would not know definitely as what is correct or incorrect information, and that would, as from the discussion, would depend on what the FDA would in the future say or what it has already said during the time of the passage of the act. And you conceded that this listing of what is allowed or what is safe can be lengthened or can be shortened, which means to say, I will repeat that as of this moment, assuming that the Supreme Court says the law is constitutional, the definition of what the prohibited act here is not yet complete because it will have to be determined yet by the FDA, or it can be changed by the FDA. My concern is that constitutionally allowable? I mean, delegating that power, that legislative power of defining a crime, because no crime.
Yes,
yes.
I think, Your Honor, the role of the FDA is not to define the crime under the statute, but to establish certain facts necessary for determining whether or not...
And effectively define the crime.
No, not necessarily. The way I look at the statute, it would operate like this. Someone wants, say, to know what the effects of an antibiotic is, and because he or she wants to have sexual intimacy with another person, and the doctor says knowingly, right, that an antibiotic is a powerful contraceptive, right, and that person suffers as a consequence or gets a sexually transmitted infection. I think, Your Honor, that is the basic purpose of the statute, which is to prevent doctors from taking advantage of their position and knowingly providing incorrect information to a patient who might actually be physically injured, might suffer from damage. So the role of the FDA, Your Honor, if I may, is not to define the statute, right, but to define certain facts that may be used for purposes of prosecution.
Define one element, effectively defining the crime. Anyway, let us stop the debate. Okay. Please include that in your memory.
Yes, Your Honor. Thank you, Your Honor.
Justice De Castro wishes to make a remark.
just want to correct ask the stenographer to change the word misleading that I used earlier.
Okay, thank you, Your Honor.
Change that to digressing.
Okay, thank you, Your Honor. I truly appreciate
I'm
it.
sorry for that.
Thank you po.
Ms. Perez, you want to have a follow-up question?
Just one more, Chief. Also, following the discussion of Justice Velasco, will not the strict or efficient or successful implementation of this law result in the reduction of the population of the poor?
Okay. There is, Your Honor, a clear answer to that under the statute. And the answer is, let me just find it, Your Honor. Okay. There shall be no demographic or population targets, and the mitigation, promotion, or stabilization of the population growth rate is incidental to the advancement of reproductive health.
So that
the
is
target, Your Honor, if I may, of the statute is at the level of the individual, not at the level of the population. It's a population control measure if the government adopts a one-child or two-children policy. But this measure goes to the level of the individual and says, we will provide you with the necessary information, services, and supplies to make your own determination whether or not you can space or size your family the way you want to space or size your family. And so, whatever population effect this statute will have is incidental to the general goal of remedying certain structural injustices in Philippine society, which is the result of, say, the operation of the market or poverty.
Is that saying that it was a surplusage when the law prioritized and specifically even defined what the poor and the marginalized is?
Of course not, Your Honor. It is simply a recognition that there are existing distributive concerns in our society, that there are poor, there are middle class, there are upper class. And it's those citizens who are economically challenged that do not have access even if they have the right. And this lack of access translates into maternal deaths on a hourly or daily basis, unintended pregnancies that define the lives of human beings. These are clearly remediable social concerns that arise out of poverty.
And let me imply from that, and from what has been stated all throughout our oral arguments, why is there an implied avoidance of the objective of this act to control the population when it is in fact an objective of this law? Let us accept that it is the objective, and let us now define whether that is constitutional or not. Let us not hide behind such terms as reproductive health, welfare of the woman and the child, etc., and try to make the law acceptable because of such definitions or such words or phrases. Let us accept that, yes, there is a need to reduce the population of the poor. Yes, the poor are the people who need to be educated. Yes, the poor are the people who need to have access to contraceptives because of the policy of the state to reduce the number of the poor. I am not expressing any bias here.
Yes,
I'm just saying let us be candid about what this law is all about and then tackle the problem that this law might meet. I mean, the barriers, the hindrance it might meet.
I recognize your concern, Mr. Justice Perez, except that, I'm sorry, I will have to disagree because as a constitutional matter, that is not the thrust of the statute. The thrust of the statute is not to control the population, but to provide a rights-enhancing measure.
Which means to say that if the thrust is population control, it's unconstitutional and you accept it?
Not necessarily, Your Honor. I'm just saying that that is not the goal of the statute. What I'm saying, Your Honor, is that a couple who would have 5 children under the RH law would be provided with the necessary information and services to space those 5 children into a period of, say, 15 years, instead of like every year, the way they produce cars in Japan. Thank you, Mr. Justice
Justice Mendoza.
It is in your
Your
comment,
Honor, I'm sorry.
page 66 of your comment, the consolidated comment, you stated that any health service provider who refuses to render service or provide information is, quote, impelled by nothing else but malice and bad faith, unquote. Why do you make this presumption?
Your Honor, let me just read it. Okay.
Why do you make this presumption?
Because I think, Your Honor, that a medical professional who is aware of the correct information, taking advantage of his or her position, decides to provide incorrect information, is a person who is acting in bad faith. And the statute has a right to people, to sanction people who are in that position and would take advantage of that position to harm or potentially inflict injury on an innocent patient.
Suppose he's just invoking his religious belief.
Then a person who is invoking his or her religious belief would be within his constitutional and statutory right to simply conscientiously object.
And
Not
he
provide
will not be
knowing.
criminally liable.
Your Honor?
And he will not be criminally liable.
He or she will not be criminally liable because that is a way out under the statute in recognition of the medical practitioner's religious concerns.
Earlier, Justice De Castro asked you what is the compelling state interest. And I'm not sure if I was satisfied with your answer or you evaded the answer. You digress, I think.
Okay. If we're
What is the
looking
compelling state interest?
15 maternal deaths per day, hundreds of thousands of unintended pregnancies, lives change. There aren't a lot of things that can be more compelling than that, Your Honor.
And for that reason, for those reasons, the state is permitted to violate the freedom of religion of a citizen, of a person.
What we're saying here, Your Honor, is that there's no violation of the free exercise right of the Constitution because precisely this is a carefully balanced legislation that takes into consideration the free exercise concerns of the religious, who also happens to be a medical practitioner, and the right of access to RH information and services of a citizen who, because of his or her economic status in life, is not able to obtain RH information or service which is available actually to those who can afford them.
You mentioned earlier that the one undergoing the procedure is his or her decision is preferred. What procedure do you contemplate?
I was informed, Your Honor, that the procedures mentioned here or contemplated here are ligation and vasectomy.
That's all, Chief.
Justice Reyes.
Clarificatory questions. I want to be, good afternoon, Mr. Counsel.
Good afternoon, Justice.
I want to be clarified on certain section, specifically section 17 of the RH bill, which provides, among others, which encourages health care service providers to provide at least 48 hours annually of reproductive health service to indigent and low-income patient free of charge. Do you agree with me, Mr. Counsel?
I think that is what the statute says, Your Honor.
Yes, that is the provisions of the statute, among others. However, in the last sentence of that specific section, the pro bono 48-hour annual reproductive health service is made a prerequisite
Yes, Your Honor.
for accreditations under the PhilHealth, is it not?
Yes, Your Honor. That is what the statute
that is
says.
provided under the law. How would you reconcile the two statements that healthcare service providers are merely encouraged to provide pro bono reproductive health service, but make it a requirement for accreditation under the PhilHealth?
Yes, Your Honor.
That is my dilemma.
The government's answer, Your Honor, is that private and non-government reproductive health care service providers are not compelled to provide free RH care service and information. They're not compelled. Therefore, they absolutely have the right not to provide the information. But they are encouraged by the statute, and one of the ways by which they can be encouraged is by giving them this privilege of PhilHealth accreditation. And this accreditation is a very benign system because the range of RH care services that they can provide is very wide, and that will include those services that a conscientious objector would be willing to provide. Then I think that is a good compromise.
Is that a compelling factor as against the first provisions of the law, which only encourages the health
yes,
care
sir.
providers?
Absolutely, Your Honor. This is not a compulsory system, but there's a government institution called the PhilHealth which can accredit. Now, what the government is saying is, if you want accreditation, right, you will have to provide 48 hours of annual pro bono services. You don't have the right to that accreditation because it's a government privilege. And so, if you absolutely don't want to provide free or pro bono RH care services, then don't do it. Then don't do it. But if you want to provide it, we'll give you a bonus, and that bonus is accreditation under the PhilHealth. And any medical practitioner, right, would be well advised to do just that because anyway, the range of RH care services available under the statute is very broad enough to cover the practice of even the religious who will conscientiously object to the RH law.
Let's proceed to another section.
Yes, Your Honor.
More particularly Section 7 of the RH Bill, which provides, inter alia, require private health facilities to provide family planning services available to paying clients, except in the case of non-maternity specialty hospitals and hospitals owned and operated by a religious group. Am I correct?
Yes, Your Honor. That is what the statute says.
The foregoing exception given to hospitals owned and operated by religious groups from providing family planning services is grounded on respect for religious belief.
That is true, Your Honor.
So that is the main purpose, objective of the law. What about in case of hospitals which, although not owned and operated by a religious group, is owned and operated by a person who belongs to a religion that objects to artificial methods of family planning? Are they also covered by that exception, Mr. Counsel?
You're referring, Your Honor, to
Section...
okay, to hospitals that are not owned by a religious group, but owned by a religious person.
Yes, religious person.
Okay, I think, Your Honor, there's a distinction. If it's a religious group, I think the statute makes an assumption, right, that they might have some conscientious objector status. I would label this particular proviso of the law as an institutional conscientious objector status, and therefore they are simply required to refer. But in the case of a person who simply happens to be religious but owns a private hospital, the general proviso, the first proviso of the statute, will actually apply to the hospital owned by that person. Meaning what? that hospital, which is a private health facility, will have to provide RH care to paying clients. Paying clients, Your Honor. And so I think it's reasonable for the statute to make a distinction between a religious group operating a hospital and a religious person operating a private hospital. Because I think a religious group operating a hospital would be an institutional religious organization. And so it's different from a person who simply happens to be religious but has enough money to establish or build a hospital.
Question, Mr. Counsel. Section 14 of the same law mandates the state to provide reproductive health education to adolescents, or those, in my view, are those from 10, 11 to 19.
10 to 19, Your Honor.
10 to 19 years old. So that is the law itself.
Yes, Your Honor.
In so doing, is the state not preempting the parents engaging in determining or gauging the emotional maturity of their children? That is, whether they are emotionally and mentally prepared for reproductive health education.
Okay. I think, Your Honor, because the state has an interest in the reproductive health and reproductive health education of future citizens of the Republic, the state is not precluded from making what it considers a judgment on whether or not age and development appropriate reproductive health education should be given to future citizens of the Republic. It is a complementary function to the primary role of parents, because parents will have their children almost all the time. They have their incentive mechanisms to ensure that their children would follow their moral or spiritual or non-spiritual beliefs. The state will have a partnership with these children only for a few hours every day, right? But the parents, they have a strong control over their children, and it doesn't necessarily have to be incompatible, Your Honor.
Thank you, Mr. Counsel.
Thank you, Mr. Justice Reyes.
Justice Bernabe.
Counsel, you said that the act of referral by a skilled health professional is an exercise of a professional duty. You said that earlier.
Yes, Your Honor.
Would you also consider it as a practice of religion?
No, Your Honor, because the practice of profession is a discipline that requires a lengthy process of accreditation. A person who visits a hospital, like I said, is not looking for a theologian, is not interested in a religious debate. He or she is looking for an expert in a particular field, medicine or one of its subdisciplines. And therefore, even if a person who happens to be deeply religious, right, if a person who happens to be deeply religious is practicing medicine, right, the face that he or she provides to a client is the face of a doctor, not the face of a religious believer.
Okay. By the act of referring, is there any compulsion on the part of the conscientious objector to accept a religious belief of another or reject his own belief?
No, Your Honor. I think it's a purely it's a purely secular concern of the government to ensure that a person who is denied access to RH information or service by a conscientious objector eventually obtains it as a consequence of that referral.
Okay, when one does an act of referral, would you already know the decision of the person being referred to?
No, Your Honor.
Then what is the purpose that is being sought to achieve by the act of referral?
What is sought to be achieved by the act of referral is to provide that patient who is denied access to RH information or service, right, what the law provides him, which is ultimately access to information and service that she couldn't get from a medical professional who is a conscientious objector.
Now, assuming that the act of referral is both an exercise of a professional duty and a practice of religion, how do you balance these two interests? I mean, which one would yield to the other and why?
Your Honor, we don't see it as a case of, as a zero-sum game where someone wins entirely and the other loses entirely. This is a compromise already. As you have mentioned, Your Honor, in your discussion with Attorney Liban, your right to belief is absolute, but your right to act on the basis of your belief is subject to state regulation. This is an act. The refusal to perform RH service or provide the information. And that act is being regulated. And the state here is giving the conscientious objector a very generous concession. You are allowed to be unprofessional. You are allowed to not perform your duty, your regular duty as a doctor. But we will impose on you a very minor duty, the minor duty to refer. Why? Because if we don't provide you with the minor duty to refer, we are creating a victim and we are privileging absolutely your religious belief. And that, I think, would actually be a violation of the non-establishment clause if the state does that.
Now, what is the implication if a skilled health professional does not perform his duty or be exempted from referring because of his religious conviction?
I think, Your Honor, if a person within a appropriate set of facts refuses to perform the duty to refer, then there is a possibility that the criminal sanctions might be triggered.
Now, the right to speak includes the right not to speak.
Yes, of course, Your
right.
Honor.
Such that the right not to speak is also protected.
Yes, Your Honor.
Now, the RH law compels a person to speak by imposing on him the duty to refer. Would not the RH law violate the right not to speak?
No, Your Honor, because there's no such thing as a universal free speech doctrine. I think that particular doctrine applies to cases where the government is compelling a citizen to speak, particularly in a public forum. And that is the classic case of the Ebralinag petitioners. In the case of Ebralinag, you have religious people who, acting as citizens, would like to exercise their free exercise rights not to speak. And when the case came before the Supreme Court recognized their right not to speak because they're being compelled as citizens to speak in a public forum and are being imposed a public duty, a civic duty to externally manifest loyalty to the state. That situation, the Ebralinag situation, Your Honor, is entirely different from an RH situation because the RH situation involves the relationship between a medical professional who has the knowledge and expertise and a patient who doesn't have the knowledge and expertise. This doctor presents himself or herself to everyone. He wears the hat of a doctor. He doesn't wear the hat of a bishop or a priest. He wears a particular hat, that of a professional. And therefore, the public has the right to expect that this person will perform his or her duties as that person of science. And so the speech component is very minimal, if there is any speech component at all. The RH law is a health measure regulating the relationship of a doctor and a patient. It doesn't regulate the relationship between a citizen and another citizen.
Now, under the implementing rules of the RH law, the conscientious objector, while mandated to refer, can provide messages of disclaimer after every act of referral or posting advertisement that communicates his effect. Does this have on the right to free speech and expression?
Well, number one, Your Honor, how the Executive Department will implement the RH law is independent of the question of the constitutionality of the text of the RH law itself. And so whatever problems, if any, the IRR might create as a consequence of the Executive Department's interpretation of the RH law will have to be tested in an as-applied basis. Because here, Your Honor, this litigation is about a petition by anti-RH advocates seeking to test the facial validity of the statute. not the facial validity of the IRR, which has which has little to do with the constitutional authority of the Congress to pass an RH statute.
Now, would you say that by this, the mantle of protected speech?
I'm sorry, Your Honor, I got lost.
No, this is it that you can provide messages of disclaimer. So effectively, you are dissociating yourself all beyond the mantle of protected speech, the act of referral, with a disclaimer.
I think, Your Honor, that the policy of the statute is focused on providing access to RH service and information. And so ultimately, so long as the patient is not converted into a victim and is able to obtain RH information or service, the government would have very little concern over how that function is performed, or whether or not in providing the act of referral, the public health professional also says, yeah, but I'm also an anti-RH statute. I think this statute, violates my religious liberty, or will send you to hell, or anything like that. I think ultimately, if the citizen, the patient who wants access to RH information and service is referred and able to obtain access to RH information or service, no criminal sanctions will apply, and the free speech implications would vanish.
Okay, thank you, Counsel.
Thank you, Mrs. Bernabe.
Justice Leonen.
Good afternoon, Professor.
Good afternoon, Dean.
May I call you that? It has been a while since we have had an intelligent conversation, or a not so intelligent conversation, is it not? So I would, of course, beg your indulgence, because at certain points I will go to certain exaggerations, perhaps even push some of the questions to its malicious extreme, because I hope you understand that we are here trying to test some of your premises, if that would be
yes,
all
Your
right
Honor.
with you. First, I was curious about your opening statement, where you said that our initial interrogatory posture should be that we should try to find constitutionality in the words of the statute rather than go find unconstitutionality. Why is that?
Because I think, Your Honor, that is the role of this honorable court within a scheme of separation of powers. That is also what this honorable court has narrated over and over again in its existing jurisprudence.
But yet we exist, and there is a second paragraph to Section 1 of Article 8, which gives us some leeway to find grave abuse of discretion. And of course, you know that there is existing academic literature,
yes.
John Hart Ely, Alexander Bickel, which says that we do have a function, and that function is to check whether there has been a democratic deficit in the political branches of government. Would you say that we could weigh the policy purposes of the Congress and the President, weigh it against the permanent values that are congealed in the text of the Constitution?
That is true, Your Honor, as a general and theoretical matter. But if I may manifest something about the grave abuse of discretion clause, I think if you talk to those who are responsible for that text, they will confidently tell you that the goal behind the grave abuse of discretion clause was to make the court not gun-shy, as it was during the Marcos years. But it certainly wasn't meant to make the court trigger-happy as an institution looking for ways to exercise its constitutional powers.
In other words, Counsel, you are saying that it is this court that looks at minority rights, gives it a second look, because minority rights tend to be overlooked in a democratic setup. Of course, the majority will have the numbers in both the House and the Senate. Is that not correct?
Yes, Your Honor.
And in this particular case, could we say that the petitioners are part of the minority in this case?
It depends, Your Honor, on how we define minority. Even if we say that petitioners constitute a minority because they are in their own words, the true Catholic, their minority rights are being set up against the rights of majority of Filipinos who are economically challenged and therefore are also part of the political minority.
Just so we are clear about where we start with our premises and our initial posture, the numbers that were told to us by both Senator Cayetano and Congressman Lagman in terms of the votes in the House and the Senate, it was not a landslide victory for the RH. Is that not correct? In other words, the majority was not slim, but it was not overwhelming in terms of the passage of the bills.
That seems to have been the case, Your Honor.
Okay. Now, if we continue with the canonical ways by which we should be thinking about this case, therefore, we should try to look at words in the statute, and if there is a way of reading the statute that will make it constitutional, your position is that we should adopt that interpretation, barring a future case where we can actually apply and find the exception to that finding.
Yes, Your Honor.
So therefore, for instance, the words in Section 9 of the law, that hormonal contraceptives and other safe, legal, non-abortifacient, etc., that if we could read that to mean that hormonal contraceptives, as proposed by, I think, Senator Pia Cayetano and Congressman Lagman, to mean only a classification,
yes,
but not a specific kind of a contraceptive, your position is that we should do that particular reading and wait for that time when there is an actual hormonal contraceptive, a brand, a kind, that will come up to this court, where the FDA might have a contrary finding.
Yes, Your Honor.
Copper IUDs, for that matter, can be questioned before the FDA. Is that not correct?
Yes, I think so.
In other words, copper IUDs, is the FDA closed about reconsidering whether copper IUDs can be in the market?
I don't think they can be closed given that they have an obligation under the RH law
Certain
to determine
pills.
whether or not they're safe.
Certain pills that have a long list of contraindications. Is the FDA now close to reconsidering those pills?
No, Your Honor.
As a matter of fact, maybe we do not know because there has been no attempt yet to go to the FDA. Is that not correct?
Correct, Your Honor.
But there is now an attempt to go to this court and say because of copper IUDs, because of a certain kind of pill, all hormonal contraceptives are therefore unsafe, and therefore the law is unconstitutional. Is that not a position that has been taken before this body?
I think that's the position of the petitioners, to engage in a shotgun method of litigation.
Shotgun, but I'm just saying that it might have been one of the positions
Yes,
that
Your
were
Honor.
taken. Now, you mentioned about facial challenges. First, just to be clear, this is different from as actually applied challenges.
Yes, Your Honor.
By facial challenge, what do you mean?
A facial challenge is a challenge to the statute based on its textual incompatibility with the Constitution.
And you say that canonically in constitutional litigation, that there are only very limited exceptions where we are allowed as a court or where we have self-limited ourselves, therefore judicially restrained ourselves to conduct inquiries in cases where it is only the text of the law not yet applied that we check against the Constitution. Is this not correct?
Correct, Your Honor.
And you say that this is in freedom of expression cases.
Yes, Your Honor.
And more particularly, would you say that this is not all freedom of expression cases, but only with respect to prior restraints, where the presumption is heavy against the law?
To use your language, Your Honor, certain core concerns of the Constitution.
Okay. However, this is the Supreme Court today. In other words, that this restraint came at a time when the court felt that it was its role within the scheme of things under the Constitution, given contemporary circumstances. There is a proposal, I think, in some of the petitions that there can be facial challenges when it is the right to life that is at stake. And this was heavily made by the first
Yes, sir.
speaker, Attorney Noche, if I'm not mistaken, during her presentation in this particular case. Now, why not? Why would you say that this court should, why can't we, as the court now, existing in 2013, in the Republic of the Philippines, not in any other jurisdiction, considering the circumstances where we are in as a developing, emerging economy, that we should re-examine this particular doctrine?
If it were, Your Honor, a right-to-life case, really, then the government shouldn't have any reservations about a facial challenge. But the right to life is not even implicated in this case, because for petitioners to make a case for right to life, they had made, a ton of wrong assumptions about the statute. They say it licenses abortion, but the statute facially says it doesn't license abortion. In fact, 7, 8, 9 times the statute says it will only provide safe, legal, and non-abortive patients. Does it violate the right of the unborn? Of course not, because it will violate the right of the unborn only if you make the assumption that this is an abortion statute. But this is not an abortion statute. If it were an abortion statute, maybe the court's special powers under the Grave Abuse of Discretion Clause may be triggered. But this is not an abortion statute, as is very clear in the statute itself.
Only if the existence of the violation of the right to life is on abortion. But of course, you have things like procreation here. The options of couples, as has been asked from you by some of my colleagues here, that is also part to life, but we will go to that later. That is another section in terms of the questions that I need to ask of you so that we are clarified in terms of the decision. Now, there is the other principle in terms of reading statutes, especially a criminal statute, that we should read it in such a way to be able to give meaning to all the words that are in the statute. Is that not correct?
Correct, Your Honor.
By the entire statute, we are saying that not only the provisions for the crime seems to have been introduced, but also where that provision is seen in the entire context of a particular law. Is that not correct?
I agree, Your Honor.
Therefore, we should interpret words such as knowing or incorrect in relation to declaration of principles, in relation to mechanisms that are provided in the law itself. Is that not correct?
Correct, Your Honor.
Can we read? Can we interject the purposes and intent of the legislature as we see it?
Yes, Your Honor.
Not as textually evident in the statute, but as
well, in a facial challenge, you have to limit yourself, Your Honor, to the text of the statute.
Again, there is 23 Section A, subparagraph 1, which I think by now even the audience in the Supreme Court may have memorized. And this has something to do with knowingly withholding information or providing incorrect information. Is that not correct?
Correct, Your Honor.
Now, the word knowing is, of course, standing by itself ambiguous. Is that not correct? Knowing. I mean, it can have a lot of meanings.
Yes, Your Honor. That is possible.
Including a biblical one, if you understand what I mean.
Yes, Your Honor.
Standing alone. Correct.
Standing alone.
But in the context of the statute, if we are to accord the interrogative posture that you have proposed, that canonically we are to try to find the constitutionality first, because of our standing in the scheme of things in the Constitution, that we should try to find a meaning that is viable. Could we not say that knowing here refers to a knowledge within a profession, as you may have argued?
Yes, Your Honor.
So knowing here means things like a doctor who treats a diabetic patient cannot provide advice that that patient can continue eating ice cream, with sugar, not sugar-free, or drinking soft drinks, etc. That would be incorrect information clearly, is it not, counsel?
Yes, Your Honor.
But there are, of course, certain things which are doubtful, such as, for instance, that a doctor makes a judgment as to whether a first-order antibiotic or a third-order antibiotic would be preferable to a particular patient. That is not very clearly incorrect information if the doctor commits a mistake. Is that not correct?
Correct, Your Honor.
Because in the scheme of things, as applied to a particular patient, some patients might be more comfortable or may have had histories with several antibiotics which they did not take in accordance with the dosage and regularity, and therefore now the doctor makes the judgment that it may not be a second but a third-order antibiotic that is prescribed. Is that not correct?
Correct, Your Honor.
Yes. So when we say knowingly prescribing incorrect information or saying incorrect information, we can frame that within the various provisions that are contained in the RH law. Is that not correct?
Yes, Your Honor. That's
yes.
correct.
And therefore, it is entirely possible that it may be constitutional. Is that not correct?
Yes, that's correct.
But it is also entirely possible that it may be unconstitutional. Wouldn't you agree, counsel?
Because it's within the realm of possibilities.
Realm of possibilities. But here, because there's a realm a possibility that it may be unconstitutional, what do you think what do you propose our posture should be? Should we not strike it down right now, just so we protect whoever might be convicted unconstitutionality in our, let us say, in our imagination? Or should we just accord this presumption first to the statute and wait until the particular case goes through the filing of an information, perhaps a motion to quash, raising the ground that this does not exist because it's unconstitutional, and wait for the certiorari action with us?
Your Honor, the exercise of the judicial function, specifically judicial review powers, cannot be exercised in a speculative fashion. In any case, there is still a case that may be had as applied.
So there are very clear areas in RH, in reproductive health. I think Senator Cayetano did say that when a physician will prescribe that kissing can make you pregnant, that clearly is a incorrect information. Is that not correct?
Yes, Your Honor.
And according to you, that is incorrect information because the science is not there, or the science that is supposed to inform the medical profession is not there.
Yes, Your Honor.
Yes. Of course, again, there are outlier issues, such as, of course, when it leads to something else. Is that not correct? Yes. So therefore, there are very clear cases, but there are also very doubtful cases. Again, counsel, shouldn't we strike it down immediately because there is the possibility that there are the doubtful cases that may exist out there, but we cannot see for now?
Your Honor, I think the function of the court is to sustain the constitutional statute, because the cause of not doing that would be to undermine the amount of political capital spent by other constituted agencies of the government just to pass, this particular statute. In any case, Your Honor, there is, again, litigation as applied where particular defendants or particular respondents can vent, their constitutional concerns against specific portions of the statute as it is implemented against them.
Now, let's go to a standard which you mentioned. The lowest standard is reasonableness.
Yes, Your Honor.
And the opposite of reasonableness is arbitrariness. Is that not correct?
Correct, Your Honor.
Again, of course, we are using this not in the layman's language, but within the context of our jargon. Is that not correct?
Yes, Your Honor.
To be arbitrary, what does that mean?
Within a menu of options that are reasonable, the legislature chooses an option that is outside of that menu.
Or there is no reason, there is no logic that will support why a particular restriction is present
I agree,
that
Your Honor.
burdens a particular right that we find in our Bill of Rights or in the Constitution. Is that not correct?
Correct, Your Honor.
And therefore, if we can find a reason from the text of the statute, not from any statement made by perhaps advocate or non-advocate, then your argument is that we should try to declare this as defeat the petition and declare the law for now as constitutional. Is that not correct?
Correct, Your Honor.
Now let's go to the provisions on education. First and foremost, why is education necessary for sex? Why is sexual education necessary?
Sexual education, Your Honor, is necessary because the physical act has a lot of implications. And those implications tread into the private realm and tread into the public realm. The things that we do in our private lives will have public implications. But more importantly, the things that we do in our private lives define us. There are forms of self-identification. And those forms of self-identification, I think, become meaningful only if we have sufficient knowledge about the various impacts of the things that we do.
But we have the family. And a reading of the Constitution can be that it's the family or it's the family's duty or family members' duty to actually educate their children with respect to sex. Can that be a correct, an absolutely correct assumption?
The family, Your Honor, is a very good platform for sexual education. But it doesn't exhaust the avenues for learning about one's body and the things that one can do.
You mean to say, counsel, that there are families within the archipelago that we have that do not teach their children responsibilities about sex, what the sexual act might be for, the ethical considerations, and, of course, what creates a baby? Are there families within our country that fails to inform?
I suppose, Your Honor, that as a consequence of certain cultural constraints or personal temperament, there are those kinds of families.
Or simply because they've inherited a culture of political ignorance.
Yes.
Which means, or a political culture that puts them into ignorance, which means that they did not have the opportunity to go through education as we have had. Their education is simply what they see on television or perhaps what they oversee in the internet, etc., and therefore they could not provide the right information. Is this not correct?
Yes. Ignorance can be carried over several generations and be entrenched.
Now,
yes, Your Honor.
if this can be the reality, the possible reality, when we say the primary right of the family, do we mean the only institution that can actually guide children to do the proper thing is the family?
No, Your Honor.
So it is possible that it can be schools.
Yes, Your Honor.
It is possible that it can be the church.
Yes, Your Honor.
By the way, when the church says that sex is only for procreation, does it have the authority to do so? A church, not all. A church.
That would qualify, Your Honor, as an institutional speech.
Regardless of whether or not there is parental consent given to the minors who attend these religious activities, still the church has that capacity to be able to inform its constituents that sex is for procreation. Is that not correct?
Correct, Your Honor.
Now, for purposes of the school, supposing that the family does not know trigonometry, does it need to consult the parents before it can teach trigonometry?
No, Your Honor.
If the parents are, of course, not knowledgeable about what actually creates a baby, simply because, again, they suffer from the political culture that puts them into ignorance, cannot the state compel schools to have a curricula that teaches them the scientific basis of how a sperm meets an egg, creates a fertilized ovum, implants, and creates a baby?
It can, Your Honor.
It can. And in the way that the law is actually crafted, is there space for families who are knowledgeable to participate in the creation of that curriculum?
There is a lot of space, Your Honor.
Because the provision that you read a while ago does say that in consultation with family groups.
Yes,
and there
Your
are
Honor.
always parent-teachers associations that usually look at the curriculum of certain... Of course, counsel, you will agree with me that certain schools can commit a mistake. Is that not right?
Yes, Your Honor.
And that mistake, of course, can that be the ground can that be the basis to find that a certain law is unconstitutional, simply because a school might not provide the correct, appropriate educational materials, or may overestimate the development of a certain group of children, materials that are either too advanced or perhaps too backward to the children. Can we declare a law as unconstitutional simply on the possibility that schools can commit mistakes?
No, Your Honor. A school may be a bad school, but it doesn't result in the unconstitutionality of the statute.
So when we say primary, it doesn't mean not only. It doesn't mean that it is only the family that will
No,
guide
it
the
doesn't,
children.
Your Honor.
Is this still consistent with, by the way, can the state impose moral values?
No, Your Honor.
But there are three provisions in the Constitution, and perhaps you can cover this in the memoranda. There are three provisions in the Constitution which mention morals and development.
Yes.
Will your answer still change? Because a while ago, you were informed that our Constitution is different from other constitutions in different parts of this planet. And therefore, it might be possible that ours is of a different character. So will your answer change, considering that there are three different provisions?
No, Your Honor. While the Constitution mentions morality and moral values, it doesn't provide any content with respect to that moral values.
So it is possible that in educating our children, they will tend to value the sexual act more, put more premium into that particular act. And being informed, therefore, will reduce their proclivities with respect to actually having sex partners, and therefore just wait, do abstinence, or be more selective in terms of their partners.
It is possible, Your Honor.
And did Congress look at the statistics in relation to fertility rates?
I assume, Your Honor, that
Yes,
they did.
and did it not find that for so long as people are educated, the fertility rates are lower?
I think there was a finding, Your Honor.
And in terms of teenage pregnancies, teenagers who tend to be educated in schools, tend to have lower fertility rates than teenagers that are outside. Is that not?
That is correct, Your Honor.
Yes. Now, let's go to a particularly nagging problem, which has something to do with, I think, the right to procreate. By the way, I was struck by a statement that you made, that marriage is not an excuse to control the right to procreate of another person. We do have conjugal rights in the civil code. Is that not correct?
There are conjugal rights, Your Honor.
Yes, and that statement you made, that is law or your experience? Marriage is not an excuse to control the right to procreate of the other individual. When you were queried on why there is no requirement for consent of the spouse for certain kinds of procedures embedded in this law.
Theoretical statement, Your Honor, not based on experience.
Okay, so looking at this right to, before we go to the right to procreate, can the state offend a religion? Is it wrong, is it constitutionally wrong for a state to offend a religion?
Depends, Your Honor, on the factual situation.
There are religious beliefs that one should wear a turban. But the state promulgates a law which says that whenever you ride a motorcycle, you wear a helmet. Is the state allowed to be able to do that under our constitutional order?
Again, Your Honor, I'd have to wait for a certain set of facts
But
to make
it
a
is
judgment.
not necessary to say that, it is not necessarily true that our Constitution says the state cannot do that.
Yes,
it is
not
possible
necessarily.
that the state can.
Yes.
Let me give another example, and this has something to do with Satanism, maybe, that you offer a virgin in sacrifice to a god, okay? Yet our law says that there is a punishment for murder and for homicide, is that not, or infanticide. So can the state offend that religion?
In that sense, yes, Your Honor.
By the way, when we say religion, do we always say something that is mean a belief that is benign and good and true?
Not necessarily, Your Honor.
Really? So there can be religions which are bad?
Again, it is within the realm of possibility.
Yes. And it could be possible that somebody does not have a religion. Is that not correct?
Very possible, Your Honor.
Very possible. And that belief of not having a God, is that also part of protected religious expression?
Protected speech, Your Honor.
Okay. Now, having said that, let's go to a few matters. There is the right to procreate. Is that not true?
Yes, Your Honor.
Is that a constitutionally protected right?
It's part of the Liberty Clause, Your Honor.
Yes, the right to life, more particularly. No person shall be deprived of life, liberty, or property. Life or liberty, I think, is implied in terms of the right to procreate. And by the right to procreate, we mean it gives an individual the autonomy whether to act to create or not to create. Is that not true?
That's true, Your Honor.
Now, let me just be clear about this. This law compels a couple not to procreate. Is that a true premise? This
False
law
statement, Your Honor.
compels the couple not to procreate. False.
False statement, Your Honor.
But the couple or whoever, the public, is presented with a full range of options, all about contraception, for them not to have a baby. Is that not correct?
Even if that is how it is presented to them, they still retain the right to reject that information, Your Honor.
So, is there a criminal penalty if somebody who listens to this presentation of the full range will not actually use a condom or an IUD or any of the contraceptive devices that are there?
No, Your Honor, that will violate the liberty right of that person.
As a matter of fact, there is a penal provision for the
Yes,
compulsion
in
of
fact.
these individuals, both for the public person who does it, as well as for employers. Is that not correct?
Yes, that is
Counsel?
absolutely correct.
Yes. So what we are saying, therefore, is that this law does not affect that particular right. So it does not reach into that particular sphere of autonomy too deeply. Is that not correct?
That is correct, Your Honor.
Okay. The sexual act itself contains a lot of choices. Who your partner will be, the ethical conditions under which you commit the sexual act, the moral choices that you make based upon your own religious beliefs, why we do it, etc. So therefore, this is also within the sphere of liberty. Is that not correct?
Correct, Your Honor.
Is this affected by the RH law?
To the extent that it enables people to have The options, yes.
But it does seem to imply that when you have a contraceptive, that it encourages you to commit the sexual act. Is
No,
that
Your
a
Honor.
correct premise?
No, Your Honor.
So why is it not a correct premise?
Because if you have the contraceptive, it means you have the option. You can actually choose not to use it.
Yes, but you can choose not to use it but have sex nonetheless. Is that not correct?
Yes,
And contraceptives are only there when you have sex. Is that not correct?
yes.
So therefore, the government is now producing a full governmental program saying to the entire population, you can have sex.
No, Your
anytime
Honor.
you want. Why is that not the case?
Because the program is meant to enable people to have the choice whether or not they can decide to be pregnant today, tomorrow, or some other time, or space their pregnancy. It is a liberal program, Your Honor. It is a liberal program in the sense that at bottom and at the end, the choice whether or not to procreate or to use the information that was given or the service that was rendered still rests with the person or the family or the couple.
Just because government says it does not mean that the public must do it. Is that correct?
Correct, Your Honor.
And here, it is not government saying have sex. It means if you want to have sex, look at these options, including the natural method. Is that not correct?
Correct, Your Honor.
By the way, by not framing this entire law within the context of marriage, are we not violating the provisions on family?
No, Your Honor. It is actually inclusive. It includes the family and individuals.
In other words, a person who is not married but is of age, just to create a situation, may actually have the access to a full range of options. Is this not? This is in the law.
It's
correct?
in the law, Your Honor.
So it destroys the family. Does
No,
it
Your
not?
Honor.
Why?
Of course not. Because it recognizes that individuals who are not married have the right to use their bodies for self-identification through the sexual act. It is within the realm of liberty. A person has the constitutional right to engage in intimate relationships, and those intimate relationships may involve the physical act. What the state is simply saying is, if you're going to engage in those types of intimate relationships, we can provide you with the information and the services and the devices so that you can enable yourself to have a greater range of options.
So you're saying, counsel, that marriage or not being married is not a natural antidote against wanting to have sex.
Again, Your Honor.
You're saying that marriage by itself is not, not being married is not a natural antidote to the natural act of having sex. In other words, you will want to have sex whether you're married or not.
Will? I'm not so sure, Your Honor. You can
You can.
if you want to and if there's a willing partner, I suppose.
Is this supported by science?
By logic,
Yes.
Your Honor.
But it is unethical and immoral to actually commit the sexual act prior to marriage. That is what some believe. Shouldn't we adopt that into our legislation?
Your Honor, those who believe that are well within their constitutional rights to act on that belief, but they cannot impose that particular belief on other citizens
Again, why is that not possible?
because we recognize the liberty right of individual citizens and the privacy of choice to determine when to have sex.
Again, that may be the case for certain jurisdictions, but the challenge to you a while ago was we do have Article 15, which is on the family. By the way, counsel, is the family defined there?
I don't think so, Your Honor. I think it's the family, as mentioned in the Constitution, is broad enough to allow individuals and couples to define the kind of family they want to construct.
By the kind of family, it can be a family where the husband and the wife lives in separate rooms or separate houses,
Yes, Your Honor.
but not actually avail of legal separation or reality of marriage. Is that not correct?
Correct, Your Honor.
Yes. For so long as they do not do something which is illegal, they can define what their family would be. As a
Yes,
matter
Your
of fact, it is also possible for families that have been declared, where their marriages have been declared null and void, to maintain their friendly relations to each other and still call themselves family under the Constitution. Is
Possible,
that not
Your
correct? It can also be possible that there is a family that has not even undergone the marriage ceremonies. Is that not
Yes.
correct? and therefore the family there is broad enough.
Yes.
And as you said, the right to one's choices of intimate partnerships of whatever kind and whatever nature is at the core of liberty in relation to your person. You choose your partners, and therefore you choose how you define yourselves. Is that not correct?
Yes, Your Honor.
Yes. So, again, this law does not reach that far. It only provides information just in case there are people that have the natural proclivities or urge to have sex, and within their sphere of ethical and moral beliefs, that they could have it and therefore may want to avail of that.
Yes, Your Honor.
Yes. Would it have been better for this law to actually contain a warning, such as breast milk is good until the age of 2 years old? So maybe here, full range of options, but it is always better not to have sex. Should that not have been in the law?
No, Your Honor.
Why?
Because I think it is not the function of the government
It might
to
have
tell
been,
us
it
whether or
might
not
have
to
been
have
better,
sex.
but would you say that it is unconstitutional because it is not there?
No, Your Honor.
Let's go to the to conscientious objectors. Can there be conscientious objectors for traffic lights?
I can't think of a reasonable
Under
way
the
to
law now,
conscientiously
under
object.
statutes now, can there be conscientious objectors for traffic regulations?
None, Your Honor.
None. Are there conscientious objectors for the crime of murder?
None, Your Honor.
None. Are there conscientious objectors for service in the military? No, I'm sorry, there is no draft. Are there conscientious objectors for people in the army not wanting to kill?
I don't think so, Your Honor.
None. Are there conscientious objectors within the police system, the PNP, for people who do not want to use violence in order to arrest?
None, Your Honor.
None. This law has a conscientious objector clause. Isn't that unconstitutional because it is unequal protection of the law?
No, Your Honor. It is constitutional precisely because it is a statement by the government that they respect that in certain areas of concern, right, they should respect the religious or ethical beliefs of some professionals.
So what makes this law different? Why is there a conscientious objector provision in the law, whereas in other laws that we have, there is no opening for conscientious objectors, clearly stated in statutes?
Well, on a practical level or at a political level, I suppose it is because there were those who lobbied intensely enough for that kind of a conscientious objector status. I think, Your Honor, that this is the first statute of its kind in the Philippines insofar as a conscientious objector status is concerned.
As a
And I
matter of
wouldn't
fact,
see-
counsel,
sorry.
what is a conscientious objector? What is conscience? Is it something that is in a code somewhere?
No, Your Honor.
No. So what is conscience?
Conscience, Your Honor, can be broadly defined as one's moral values, system of belief, right?
Let me get this out of the way immediately. A conscientious objector is someone that believes in a particular religion. That is the
Not
only.
necessarily, Your
Not
Honor.
necessarily. So it's possible to have a conscientious objector that is not Catholic. Is that true?
Possible, Your
Yes. So conscientious objector. How do we know that the objection is really part of one's conscience? Are we not looking too deeply upon the individual?
If you look, Your Honor, at the statute, on its face, it is a very generous conscientious objector status. There aren't a lot of items. There's no compliance mechanism in so far as substantiating the nature of your conscientious objection.
Isn't this vague?
No, Your
Because
Honor.
it allows any kind of person to say, my conscience tells me, that little voice inside my head, the good part, tells me that I should violate this or that I should not do this.
Your Honor, that's a case for declaring the law constitutional because it's generously favorable towards respecting a person's own moral values.
But as you said, not if there is another right which is involved. You remember the harm principle of
Yes.
Locke. As you said, in Ebra Nilag, there was nobody that will be hurt by it.
Yes.
If there is somebody within law and economics, the externality is too broad
Yes.
that nobody is actually hurt by not standing up in attention, by just simply standing up and not saluting the flag. Is that not correct?
Yes.
Here, there is a particular person that is going to be hurt, and that is the patient.
Yes.
Here, does it allow does it allow the operation of the conscientious objector provision only if the patient is also having the same kind of conscience?
No, Your Honor. In
So
fact,
it's possible that the patient really wants to know what is the full range of options.
yes.
And therefore, again, isn't this clause by itself the one that is unconstitutional? Because it creates a gaping hole as against people that want that implementation. It affects a right, the right of the patient. It is unequal protection of the law.
Your Honor, that's a very good theoretical point, but I don't think the petitioners will want to go there. Finally, that is not the question before us. This is not a case for declaring the conscientious objector status unconstitutional on the ground that it creates an unnecessary burden on the part of a patient. In fact, Your Honor, it is a manifestation of the level of solicitous regard of the state insofar as respecting the religious concerns and ethical concerns of medical professionals.
What is the position of government? Can we declare this clause, conscientious objection, as unconstitutional? Just this clause.
The position of the government, Your Honor, is that this is a carefully balanced clause. This is a carefully balanced provision of the law that takes into consideration the concern of the religious objector and the concern of the citizen.
Okay. Here we have conscience being defined now. A lot of the petitioners belong to a particular religion. Of course, because the argument was not won within the political department, they come now to this court claiming that there is such a violation of a religion. Is it really a violation of religion if the state does or compels an act which is not within the belief system of a particular religion?
No.
Not part of freedom of religion.
No, Your Honor.
Again, looking at Section 5 of Article 3, and I think Justice Bernabe had outlined it before. There are two parts. One is non-establishment, and the other one is the free exercise. So non-establishment clause, are we establishing the anti of a particular religion just by sort of a reverse? In a reverse way, disestablishing a religion by coming out with the RH law?
No, Your Honor.
Why not?
Because, again, at bottom, Your Honor, people are allowed to use their religion as a means to morally judge the RH law. They can reject the information, they can reject the service, they can reject the devices that may be offered to them. In fact, a citizen can absolutely not go to a public health center if he or she is totally against the statute and the subsidy.
We are taking a risk here with respect to that particular religion. Okay, let me ask. Can a priest, during a mass, say that the RH law is immoral?
Yes.
Will he be incarcerated because of this law?
No, Your Honor.
Will a priest be incarcerated because it says that a copper IUD actually causes more harm than good?
No, Your Honor.
By the way, is that incorrect or correct information?
Regardless, Your Honor.
Not yet. Probability is either way. So therefore, it does not prevent the church from actually saying its mind in relation to this particular law. It only prevents the medical professional from actually it doesn't compel the medical professional to actually say something. Is that not correct?
No, Your Honor.
It simply states that the medical professional should refer it.
Yes, Your Honor.
By the way, is this within the jargon or the profession, within the rules of the profession of the medical profession? Is this accepted?
I have done some research, Your Honor, and apparently it is.
Yes, among the organization of OB-GYN that our doctors belong to, as well as the medical community, there seems to be some accepted ethical regulations relating to these things. Very much appreciate if the Solicitor General and the petitioners would take a look at this so that we are able to look at it. In other words,
do that, Your Honor.
we have just, the RH law just legalized medical practice. Is this not correct?
Legalized.
Legalized medical practice.
I
Again,
think medical practice has always had some legal aspects to it. And the RH law is simply a way by which the government, given its social concern, ups the ante by regulating, to some extent, the relationship between a medical professional and a citizen.
Okay. Maybe a few last points. Are we reducing the number of the poor by killing those who are now persons who belong to the poor by this law?
No, Your Honor.
We are not. In other words, the poor population will be the same. Is that not correct?
Correct.
Are we creating, with this law, is the Congress creating the possibility that there will be more informed choices for poor families so that they can opt to have 10 children or only one?
Yes, Your Honor.
Yes. In that way, we are not actually reducing the number of the poor or actually killing off the poor, but we are, by this law, actually presenting certain options to the poor. Is that not correct?
Correct, Your Honor.
So, is this population control?
No, Your Honor.
Why is it not population control?
Because number one, the statute says so. And number two, it is not population control, it's a rights enhancement measure.
The right to procreation, is that absolute?
No right is absolute, Your Honor.
The right to procreate means the things that come before the sexual act and the things that come after. Is that not correct?
Correct, Your Honor.
Yes. If there are children which are uncared for by the family, who takes care of them?
The state.
The state. And by the state, who do we mean? Does it mean our public officers? Or does it mean the public in general?
Both, Your Honor.
So to a certain extent, can we say that the right to procreate is sometimes also circumscribed? That there is a sphere of autonomy granted by our Constitution, but at a certain time, given the right case, given the right legislation, that there can be limits to the right to procreate.
Yes, Your Honor.
But are we there yet?
No, Your Honor.
No. This law does not produce numbers. Is that not correct?
No, Your Honor.
It just, in fact, it says that the demographics that will result from it is simply incidental. Is that not
Correct, Your
correct? Okay. We are taking a risk with the RH law. Is this not correct, Counsel?
Every legislation is a form of risk.
Every legislation is a form of risk. We are depending on the wisdom of people who were elected by us, no matter how imperfect our electoral system may be, to guide us in terms of what our future will be. Is that not correct?
Correct, Your Honor.
Is it the role of this court to rethink that? Or is it the role of this court to simply see whether they have exceeded the frame provided by the Constitution?
It's the latter, Your Honor.
And in your evaluation, do you think that this is worth the risk that this court might give in terms of declaring this law?
Your Honor, in my evaluation, these petitions present constitutional non-issues.
Is the Solicitor General open to actual cases where it might be clearly shown that some of the fears that the petitioners have expressed actually come true, and that the Solicitor General will take sides with the petitioners at that appropriate time?
It is possible.
Okay. Thank you, Counsel.
Thank you, Justice Leone.
Justice Carpio.
Counsel.
Yes, Your Honor.
But in your answer to Justice Leonen, you said a facial challenge can also be mounted if the violation of fundamental constitutional right.
Certain core concerns as mentioned by Justice Leone.
Yes, so the petition mounted a facial challenge because they allege a violation of religious freedom. That's a core constitutional right, correct?
That is their claim, Your Honor.
Okay, but on its face, it satisfies that requirement. They're claiming that the law violates their religious freedom. Correct? That's the claim.
Yes, Your Honor. Yes.
Now, what is the high bar that the petitioners have to overcome in a challenge like that?
No constitutional application, Your Honor. That is the high bar.
No, the high bar is that if you mount a facial challenge like that, you must prove that under all circumstances, you are correct that you violate freedom of religion.
Yes, Your Honor.
Now, that's what I was saying, that if you use condom, there can be no violation, correct?
Yes, Your Honor.
Okay, let me go to another matter. Can court invalidate a law like the RH law on the ground that Congress committed grave abuse of discretion amounting to lack of jurisdiction? In other words, there is no specific provision of the Constitution that's violated, but this court just deems it that Congress committed a grave abuse of discretion. Can we do that?
The court cannot do that, Your Honor.
Why?
Because the power of the court to declare an act of Congress unconstitutional must be found in a specific prohibition of the Constitution.
Okay, so the grave abuse discretion, the extraordinary certiorari power of this court cannot validate a law. That's what you're saying.
It cannot be used to invalidate a law on purely policy grounds, Your Honor.
Cannot invalidate a law outside of violation of a specific provision of the Constitution.
Yes, Your Honor.
Okay. About an act of the Senate or of the House. For example, petitioner comes here and says that they are compelling me to testify in a legislative hearing, and what kind of power do we exercise? A judicial review or extraordinary certiorari power, or just an ordinary review power?
It depends, Your Honor, on how the petitioner comes to the court.
Yeah, there's no law that was passed by Congress. He was being compelled to testify, and he doesn't want to testify.
If abuse of discretion on ground of possibility of violation of Article 6, Section 21 of the Constitution.
Okay, so it's a grave abuse of discretion. But that's not the extraordinary certiorari power of this court.
Not necessarily, Your Honor.
Not necessarily. Okay, thank you, Counsel.
Question from Justice. One question from Justice Mendoza. Finally, please let me close this with.
Your Honor, could you?
It's
I'm sorry. Could you direct me to the
Section
particular?
3C. Implementation.
Sound replacement rate. I think, Your Honor, in demographic studies, I'm not particularly sure. There is a rate at which we can be confident that the population is being replenished. I think, Your Honor, I think it's about 2.1, but I'm not so sure. Is it 2.1, Your Honor?
Is this related to?
No, Your Honor. I think this provision is purely hortatory, no normative force, Your Honor. It only talks about sound replacement rate without any compulsion at all. Your Honor?
Subparagraph E of the same section.
Okay.
This refers to the duty of the state
Yes, Your
without bias to all methods of family planning, etc.
Yes, Your
So, can we relate this to the information referred to in Section 23? Is this state-supported or sanctioned information? We associate.
I'm not so sure, Your Honor. These are guiding principles for implementation. I don't think they have the kind of normative force that the penal provisions of the statute would have. I don't think they're meant to provide articulation with respect to the elements of the penalties imposed under Section 23.
I'm just trying to understand the
Yes, Your
contained
Honor.
in Section 23.
Yes,
And
Your
I agree, there provision of the law to find out the meaning of
Yes, Your
information as used. And this is the only section.
Your Honor,
So
if you want-
it may support.
Okay. Your Honor, I don't think that is the thrust of the statute.
You,
I think the thrust of the statute under the guiding principles is to push the Department of Health to use its resources insofar as promoting and providing information and access without bias. That is all that there is to it, I think, Your Honor.
it's just the devices or
I think,
devices.
Your Honor, that the right of citizens to dissent is fully covered by the free speech right. A person who totally disagrees with the RH law or an academic who disagrees with the findings of the FDA has the absolute authority to disagree, whether as a citizen or as a scholar. What the RH law regulates, Your Honor, is a situation where in a case where there exists a patient-doctor relationship, that doctor should not take advantage of that position to knowingly provide incorrect information. I think, Your Honor, that is the general idea behind the statute.
Just want to be clarified. In pages 73 and 74 of your comment, it was stated there that in addition, the framers of the RH law intended to impose the mandatory nature of reproductive health education only in public schools. You confirm that?
I will, Your Honor, the statute itself seems to say that.
Yes, Section
So
14.
facially,
Section 14.
yes, Your Honor.
However, in the IRR, Section 11.03 and Section 11.05, that with respect to private schools, under Section 14, these provisions are may only be adopted at the option of the parties by the private schools. I mean,
Okay.
but in the IRR, it appears that the private schools are mandated to provide such young people supportive environment where they have access to some services stated there.
Okay.
And also in Section 1105, it's stated there that the DepEd, which covers public and private schools, shall integrate responsible parenthood and reproductive health information into its formal and non-formal education program, as well as community-based education programs and the indigenous learning systems. CHED, TESDA, and other concerned agencies shall likewise integrate this into each degree and non-degree education programs, orientation, etc. Is this not inconsistent?
Your Honor, is that a constitutional attack on the statute? I think, Your
Right.
Honor, that we cannot interpret the we cannot look at the constitutionality of the statute by scrutinizing the IRR. Again, Your Honor, I have already mentioned that the IRR is the work of the executive department. It's how it interprets the statute. Any problems with the IRR can sufficiently be covered by an as-applied challenge. The particular litigation before us is a facial attack on the statute, not on the inconsistency of the IRR with the statute. And finally, Your Honor, I don't think the petitioners raised that as a question in the first place in their petition.
So, what the government cannot place in the law, it places in the IRR.
Your Honor, I don't know.
No,
In fact,
because-
as a theoretical matter, I suppose your underlying assumption is that it's unconstitutional for the state to regulate private schools in such a way that it can mandate.
No, I'm just asking
okay.
this conflict.
I don't know about the conflict. I'm here to defend the statute, not the IRR. In any case, Your Honor, as a theoretical constitutional matter, I don't see any problem with the state regulating private schools to mandate age and appropriate development reproductive education on the ground that private schools are regulated by the state in the first place anyway.
But in Section 14, it may just be adopted by private schools.
Yes, Your Honor. What I'm saying is that the statute, as written, focuses on the public school system. And it also says that the curriculum developed by the DepEd may be adopted by the private schools. I think that is a constitutional line drawing on the part of the legislature. Whatever it is that is found in the IRR, Your Honor, is not a matter placed before us today. And if there's any constitutional challenge as to whether or not the IRR went beyond the mandate of the statute, that can be remedied, Your Honor, in an as-applied challenge.
Okay, that's all.
Thank you, Justice Mendoza.
Question from Justice Perez.
As regards this as applied and facial attack on the law, looks like there is that this choice which was suggested, whether or not to declare the law constitutional right and constitutional right now, or wait for a criminal prosecution to be actually done against, filed against a person, and then
Yes,
let
Your
us decide whether the application is constitutional or not. May I just inform everyone else about a fact that the harm done to a person is not only when a person is criminally convicted of a crime. The prejudice starts at the very time that a person is charged criminally, which is the reason why there is such a rule on prosecution, that
Yes.
you don't file a case unless you pass the prosecution stage. But more than that, even before the actual prosecution, the fact that a case is filed against a certain person, that does it. The person is already prejudiced, and I would not accept as a premise or accept the possibility that we go into the issue of this prohibited act only after a person has been charged. And may I just repeat my observation that you, of course, attack or defend this law from the grounds from which you're coming. Because I saw that you avoided that issue of whether or not this is a population control measure. You said this is not. But I feel that the petitioner would attack this law from that angle. And if you do not proceed also, well, partly or wholly on that angle, then there'll be no meeting of the, what do you call this, the meeting of the arguments and counter-arguments. That's all, Chief.
Thank you, Mr. Justice Perez.
Okay, I will now close these proceedings by giving instructions to both the Solicitor General, specifically, and then to both parties. Now, I do not want to prolong our agony. That's why all my questions may just be answered in the memorandum of the Solicitor General as well as the other private respondents.
We will do that, Your Honor.
However, Solicitor General, if you wish to interject at any time and answer it immediately now, it is also perfectly fine with me, but please keep the answers brief. The first question, kindly go to Section 7, please, of the law. Access to family planning. Now, you have been standing already for 4 hours. That's why I will mitigate your pain by reading myself the first portion of Section 7. Access to family planning. All accredited public health facilities shall provide a full range of methods, which shall also include, etc., including for poor and marginalized couples having infertility issues who desire to have children. Do you see that?
Yes, Your Honor.
Okay. What is the relation of this phrase in Section 7 to the theory that this is an anti-poor program that seeks to reduce the population of the poor? You may wish to answer now, or you can put it in your memorandum.
Memo, Your Honor.
Okay. Solicitor General also wants to go home. Now, let's jump to the second paragraph of the same section. No person shall be denied information and access to family planning services, whether natural or artificial, provided that minors will not be allowed access to modern methods of family planning without written consent from their parents or guardians, except when the minor is already a parent or has had a miscarriage. Question, how is this particular paragraph related to the proposition that this encourages sex among minors? Okay? You wish to answer that?
In the memo.
Oh, thank you. Now, let's go to Section 23, Prohibited Acts. The following acts are prohibited. For A, any health care service provider. And remember how Congressman Lagman and I discussed the structural deficiency of Section 23, paragraph E.
Yes,
now, along the same line of questioning, where can we find the definition, as asked by Justice Velasco, of the term health care service provider? Is the fact that a public health care service provider defined in Section 4, paragraph N, sufficient for this court to understand the meaning of a private health care service provider? Or should we refer to the implementing rules and regulations, which refers to healthcare providers? Now, so there are two sub-questions there. Okay? Now, with respect to the healthcare provider, under the rules and regulations, does it make a difference that they are called there as healthcare provider and not healthcare service provider? Does the fact that there is a missing word indicate that there is a difference? That the tautology being proposed is actually refers to different objects. Okay, and if this is so, will it provide us enough basis to say that this is a criminal statute that has sufficient definitions for purposes of punitive action? Okay, next question. You have already had a lot of propositions about knowingly withholding and incorrect information. You had a question from Justice Abad on what are the programs and services that information must be provided on. Now, identify for us, please, how the state will be able to locate programs and services, information on which will be provided, or will have the healthcare service provider will have a duty to give information on. Okay. Now, if you have already located that legal source, and the question is, if the terminology of healthcare service provider includes private healthcare service provider, which includes private hospitals and private doctors, is the state duty-bound then to provide them information on programs? Okay, on programs. Because I ask you to refer to the definition of reproductive health program under Section 4. I'm sorry. Paragraph R. Okay? Reproductive health care program refers to the systematic and integrated provision of reproductive health care to all citizens, prioritizing women, the poor, marginalized, and those, I don't understand why it is invulnerable. Perhaps it is invulnerable, not invulnerable, no? There might be a typo error there. It should be two words, in and vulnerable, correct, Congressman Lagman? Not invulnerable, no? In vulnerable or crisis situations. Is there now a duty on the part of the state to provide a way by which private healthcare service providers can have access to information on reproductive healthcare programs as referred to under Section 4, Paragraph N? And what is the implication of the fact that this is a government program on the criminal liability of private healthcare service providers? Then we go again to the same Section 29, Paragraph A. Services, programs and services. Now, I have found that in different portions of the statute itself, services include the provision of information. So I don't understand the distinction between information and services. It appears that services includes providing of information. Okay? So can you kindly please break down the elements of 23A1? In other words, element A, knowingly withholding information, or same A, restricting dissemination thereof, and or intentionally providing correct information. For every subgroup of a crime, kindly break down the specific elements and the legal basis for the determination of the elements of that crime.
We will do that, Your Honor.
Kindly also provide for us, if there is extant in any particular statute that is relevant now, the legal definitions of these phrases. Because from my present impression, they seem all jumbled up. It does not fit the classical structure of criminal criminal provisions that are very precise. It seems to be policy statement, not a penal clause. Okay, now for 1 and 2, can you please answer for us why there is no exemption for the conscientious objector contrary to the situation for the person under paragraph 3. In paragraph 3, it is the refusal to extend service and information on account of, okay? Refusal to extend. That's why I'm confused about the distinction between between 1 and 3 of paragraph A. In 1, knowingly withholding information, now here, refusing to extend quality healthcare services and information. What is the distinction between 1 and 3? And if in 3, you exempt the religious objector, the conscientious objector, from criminal culpability, why do you not exempt the conscientious objector from criminal culpability in 1 and 2? I also want you to clarify a statement I heard earlier that the public health care service provider is duty-bound already, and the religious objector ability or exemption is only available to a private health care service provider. I don't see any classification here. As long as he's a religious objector, whether he belongs to the private sector or he belongs to the government sector, he seems capable of making use of that exemption. So you are clarifying that that was not the intention of your statement?
No, it wasn't.
Okay. Now, clarify for us also the phrase, refuse to extend quality healthcare services on account of. In other words, in paragraph 1 of A, it is the knowing withholding of information or the provision of deliberate provision of incorrect information. Now in 3, it is the refusal to extend service and information on account of. In other words, if there is a refusal to extend quality health care service, but the refusal is not on account of one's marital status, gender, age, religious convictions, personal circumstances, or nature of work, then there is no criminal liability. You see? Therefore, this whole religious objector debate is superfluous because you just refuse and you don't state the reason for the refusal and you have no criminal liability. Am I correct?
We'll respond to that in the memo.
That seems to be the first impression if you read it. If you cannot prove the second element, that the refusal is on account of that person's specification, religion, status, age, sex, gender, nature of work, etc., then there is no liability. In fact, if I read it the third paragraph literally now, there is no requirement that everyone is required to extend quality health care service. The only requirement is in paragraph 1, which is the withholding of information or the restriction of dissemination or the restriction of such information and the provision of incorrect information. That seems to be the only one here that the healthcare service provider is required to provide, and of course, if the refusal to perform procedures because of lack of consent. See, do you understand my difficulty with the structure of the law itself? Okay, and then my last question, there is again, and then on the same paragraph 3, subpara 3 of para A of 23, referring a person to another facility or provider, is it the same or analogous to the referral of a person to seek a second opinion? And what is the medical standard for the provision of a second opinion? Is it is a doctor required to refer to another doctor for a second opinion, the patient, because the patient is not comfortable with the opinion given by the doctor? How is it different? Because this time it is the doctor who is not comfortable about giving an opinion. And is this difference legally material?
Okay.
Okay. Now, you go to C of the same section, section 23. Kindly relate this to the labor code provision, which requires employers to provide family planning.
Contraceptives and IUDs.
Yes. Kindly relate this. I want to find out how is it now related to that. And may I refer you to section 24 on penalties,
Yes,
the second paragraph. If the offender is a juridical person, the penalty shall be imposed upon the president or any responsible officer for each particular offense defined and each particular subsection of 23A, remember, has several crimes in it. A has knowingly withholding, providing incorrect, etc. Kindly define how a corporate officer, the president, will be responsible if there is no provision by the hospital which he is heading of such action? Or does it require that it be by corporate action? What is the situation being contemplated in the second paragraph of 24 before there can be accountability for criminal violations?
Okay.
Is there
We will
anything
do
you
that,
want to respond to right now? Okay. Thank you very much. You may also wish to, I think, just for the memo, just instructions, not questions.
Yes.
Please do not reply. So, instructions for the memo. Are these additional points for the questions? Okay, 2 more talking points for your memo. Okay.
Yes, Your Honor.
Section 7 that was cited here provides that written consent from their parents or guardians before minors will be given access to modern methods.
Yes.
But the section 4, letter Q, which defines reproductive health care, which will be the subject also of reproductive health education for adolescents and adolescent and youth reproductive health guidance and counseling, says that what should be available are full range of methods, facilities, services, and supplies. So what you need consent from the parents are the methods. But there's no need for consent for making available facilities, services, and supplies. So I want the sample clarification there, that point. And the other one is, is there a penalty? Does the law provide? I see a lot of penalties will be those who will not provide these services. But
Yes.
I want, is there a penalty in this law for those who will make these methods available to minors without the parents' consent? You tell me if there is. And the other one, is there a provision also that punishes sale of contraceptives to minors, or teaching of matters to, or teaching these compelling, as I said here, compelling private schools to teach the curriculum prepared for sex education by the Department of Education, when it says only may. Is there a penalty for that?
We will do that in our
Thank you.
memo, Your Honor.
Thank you. Now for both parties, you are hereby given 60 days from today within which to file your respective memoranda. Anyway, we have already recordings of the podcast. The podcasts have been publicly available. You can make use of your time even before you await the release of the transcripts. And we hope to finish the transcripts as soon as possible, but this is a very liberal period already, considering the length and the number of questions that have been raised. So I thank everyone for their forbearance. This session is now adjourned.